petition for tomorrow, Lordship.
For motion?
Yes, Lord.
Yes, it's also, Doctor, I think you mentioned for listing of an I for packeting of an internal model also.
When?
Because, tomorrow will also be filled with.
What interim order has been passed?
That's it.
What interim order has been passed? What interim order has been passed?
The tender process has been, state lordship.
Huh?
Tender process has been state lordship. What happened lordship, before they approach this honorable court.
Okay, day after. Day after. Okay. Tell everybody that the matter will be disposed of.
Top of the list item 1 and 2. Pathak.
Excuse me. But the lordships have heard the matters in length. As far as the son is concerned, lordships have, I think, seen the regulations of the bank.
Yes.
Yes, ma'am. Not on going upon the it's 95 regulations. It's, the definition of child lordships have already seen. As far as the definition of child is concerned, and even the bank has made a statement that not as far as legitimate or illegitimate, it really doesn't make any difference. And if the child, that is the son, gets, then
We are concerned with only one question of law.
lordship.
Below were justified in appropriating the entitlement for pension between the appellant number 2 and the respondent number 2, her mother.
Yes, that is the division that was the learned courts below made.
Mother and other sister, without taking into consideration of the definition family defined in regulation 2, read with regulation 39 of the.
Lordship. That is
That's
the
the only thing.
that is the only issue. My submission, my lord, remains that, and the bank has not objected seriously to that. My lord. The bank has also said that as far as the child is concerned, the regulations are, my lord, silent on whether it has to be a legitimate or illegitimate child. That is not, my lord, I, my lord, today limit my submission to the aspect of the wife. Wife. The definition of wife, my lord, if, lordships have it, my lord, in 210, my lords. Definition of family, rather.
There is a somewhere there is regulation. I've kept
Yes,
it.
95 minutes. Central Bank of India employs pension.
Regulation এখন আছে deduction separately রাখা আছে regulation of. You are now arguing on the wife.
On the wife.
You can't argue on the wife. Last time you came up on the wife.
I,
No. That you cannot be permitted because you see on 18 to
Lord,
so and so Mr. Sharma so and so submitted by Mr. A. Ganguly, the learned counsel, the edition is that our player could perhaps not be a substantial question of law involved in the. So the however, the appellant number 2 would be entitled to the family pension in terms with the regulation 1995 as such as in as much as from the definition of the term child in regulation 2Q and family in so and so, the appellant number 2 is entitled to the whole of the pension. He therefore submitted additional substantial question. Oh, you cannot be allowed to argue this.
There are two judgments of the Supreme Court, my lord, including one.
Every time you keep on asking, changing the thing. Initially,
changing.
the matter was different.
Lord,
Then it keeps on changing. Now, in view of the recent judgment of the Supreme Court, this court has the problem is that this court cannot additionally frame any further substantial question of law unless you give good
my
reason.
lord, perhaps the question of law that is already framed by your lordships, that would cover wife also, my lord, because specifically, my lord, appellant number 2 is not, my lord, because here we are, my lord, challenging the.
Now your question is appellant number 2
Lordship.
is the son
Appellant number 2 is the son.
and recent and he will become 25 years.
Yes, he
And
will.
he will lose out.
Yes,
That is your case now.
yes. Of course, he will be entitled
Should
to
have
claim.
thought about it when you were arguing the matter earlier.
No, no, the learned trial courts.
You
on the-
on your own, when I asked you specifically about this aspect, you said, no, I have nothing to say. I can't argue on the aspect of
No,
the
that is
wife.
regarding, my lord, the valid or invalid marriage. But subsequently, my lord, if the substantial question of law as framed by your lordships is seen, it covers, my lord, the aspect that learned trial court and first appellate court, my lord, both have said, what have they done, my lord? They have said that, my lord, because the marriage is void, so therefore, my lord, only the son will get, wife will not get, and the son will share it with them, my lord. Now, if the son gets, my lord, let us say, assuming that the son gets, and the lordships have perhaps taken the view the son is entitled, then they are in any way ousted, my lord. They are not affected in any way. That is first part. Second part, my lord, that there would be a question whether, my lord, the wife definition also, whether the wife means only the legally wedded wife. Because in all the judgments where the wife has, my lord, been debarred from getting the pension, are cases arising out of cases where there was a second marriage in the presence of a living spouse.
So are you therefore submitting that then the central bank becomes a necessary party, the party of
Yes, yes, party, and in fact, he was always present also. Today he is not present. Mr. M. Sharma has been appearing for the bank. And he has made his
this,
submission.
it becomes difficult now. You cannot change your keep on changing the stand.
Stand will be the same, that the division made by the learned courts below was wrong. The division, that was the apportionment made by the learned courts below was wrong. That is
Yes,
the aspect.
that I can go into that.
Yes.
But I can't frame another once you have given up that appellate number 1.
That substantial question of law which your lordships have framed. I
That
have
is only whether they were justified in appropriating the entitlement for pension between appellant number 2
yes.
and the respondent number 1.
Yes, that is, it would cover, my lord, because whether it should be restricted between the appellant number 2 and the respondents. In any case, my lord, if the appellant number 2
Hey,
gets.
where is the hey, yeah, logo rakha is the part of that record. I've kept it on as X, letter X. Here is the copy. There, down below. Hold on. Now. Now, why would Nova come in? You see, if you see the definition of family,
Good.
family in relation to an employee means wife in the case of a male employee or the husband in the case of a female employee.
Good.
So therefore, the question of the wife coming into the picture does not, because it is a concurrent finding of fact
Good.
arrived at by both the courts that it is not the wife.
Well, that is the precise. Well, the fact of the matter is that the relationship of husband and wife. Well, the
So that can I cannot go into. This is a concurrent finding of fact.
but if that finding, well,
Unless you say it to be perverse, there's nothing to say it to be perverse
No,
because it cannot be a wife in terms with this Christian Marriage Act.
Lordship. The Christian Marriage Act, my lords, herein the Christian Marriage Act or Hindu Marriage Act may not be perhaps entirely relevant, my lords. Because, my lord, the aspect is here we are dealing not with the immovable properties. Here we are dealing with the issue of family pension. And
No,
family,
no. That might be for the purpose of family pension.
Yes.
But here it says wife.
yes,
But to be a wife, you
Yes.
have to be a wife in terms with the act recognized by law.
but here, my lord, the distinction that is made in, let us say, the CCS pension rules.
No,
that-
no.
that
Mr.
distinction is-
Ganguly, nothing doing. The question is, wife does not come into the picture unless he is wife. But the fact that it is a concurrent finding of fact that she is not the wife. I'm going to stick on to that.
Well, that finding of fact, my lord, may apply as far as immovable property or succession is concerned. But as your lordships have seen,
Everything here also, because here it says wife.
Yes.
Child is a different thing.
Lord,
Child, obviously, the child means the child of the
Child.
employee. There is no quarrel with that.
yes,
It is not to be recognized to that effect.
yes,
So the child will definitely get it.
Lord.
But the fact remains to be a wife, it has to be a wife recognized by law.
Lord,
There's
if
no
I may
quarrel
just,
with that.
if I may just place two judgments,
So leave us.
the lordship
Show me
may
the judgment.
only go through these two judgments, and then, my lord, because the findings of fact, my lord, I can only limited extent, my lord. My lord, the learned counsel appearing for the bank is also present. My lord, the first one, my lord, is 2023 11 SCR 130.
You are on 2023?
11 SCR 130, my lord. Shirma Bai's case. My lord.
Okay.
If I may take a lordship to it. If I may have lordship to para 11 onwards.
These judgment is okay, but the fact remains that here there is a finding of fact that there couldn't have been a valid marriage.
If I may say so. In this case, my lord, there was a, that is what I was
I
saying.
read it.
Yes. Look, in this case, there's a statutory bar, my lord, that you cannot contract a second marriage having a living Hindu spouse alive. This statutory bar, so my lord, it comes under the degree of absolute prohibition. In spite of that, my lordship.
No, that is not the question. Here, you see, there was a marriage by that particular person
Yeah.
earlier with another person.
Yeah.
And at that point of time, he married this
Yes.
person.
This is appellant.
Yeah. And then the question is, then they got divorced.
The first one.
The first one got
Yeah.
divorced. And there was a decree of divorce.
Yes.
Thereupon, there is a cohabitation
Yes.
together. And as such, there is a presumption on the
Right.
basis of that there was a valid marriage.
That is there.
There is a presumption. But the
Yeah.
fact remains that is a case of presumption when you are only against the bank.
No.
Dispute could have. But when there is another suit being filed out here,
No.
wherein it says that there is not a valid marriage,
No.
and that presumption is no longer there in view of the finding of fact.
No, the learned courts below have only gone on the aspect of that the rituals were not performed and that the deceased husband did not convert to the.
Whatever may be, that is a finding of, you see, the presumption cannot be brought here. If it was a simple case by you against Central Bank of India, understood.
No.
But it cannot be done in view of their suit being filed where there is a finding of fact that it was not a marriage.
Yeah.
So
No.
there the problem arises.
No.
I have no problem in giving the juror. Neither Mr. Hawk would have any problem
No.
if he is not successful otherwise.
Yeah.
In getting it, taking into account that the Central Bank of India will be a brand. He would not have.
No.
But the problem is when there is a finding of fact arrived at,
No.
that there is not a, so the question of presumption you can't bring in any further unless I hold it that the finding of fact is perverse, which I cannot, taking into account that the facts otherwise show that these are there's no perversity out there on the
Well,
basis of evidence.
No, in this case also, marriage of this appellant before the Supreme Court with the Subedar was a void marriage when it was contracted during the pendency of the first marriage. So they had, their relationship arose out of a void marriage. And
But then after the granting of a decree for divorce in the first marriage,
lordship.
there is a cohabitation.
And before also.
Eh,
Before
Maybe before also,
Okay.
but there is a they are continuing, and on the basis of that, the presumption the court says that there is a presumption that there was a legally valid marriage,
Lordship.
and on the basis of that, the court gave it.
Yes.
Therefore, I'm saying
Lordship.
if it was a case between you and CBI, no problem with this court, but with the finding of fact arrived at
Lordship.
that a presumption concept is out.
Lordship.
That's the problem.
But the key aspect that Supreme Court has considered in this case is the aspect of cohabitation. Now, learned courts below here also in this case also have not denied that there was no cohabitation. There was a cohabitation. There was a marriage ceremony which may not have satisfied the requirement of law. Pursuant to that marriage ceremony, there was a cohabitation. There was a child born out of that. These aspects are not disputed and could not be upset in the findings of the learned trial court and first appellate. So, here because we are for the limited.
So you have to therefore argue on the point that you see there is a finding which is not based upon the law and facts
Yes.
that there was not a valid marriage.
Initially, the substantial.
Which I made it. I asked you many times why you are not making that submission. He said, with all fairness, my lord, I would give up this. I would not insist on that. Wasn't it your submission? Then I asked you many times on that aspect. Why you're not fighting for the
this-
wife?
This couple of judgments were not in my notice at that.
Oh, every time you keep on changing. How do I take care of it?
The-
Now, for that, I have to again frame another question of law because the CBI will be otherwise prejudiced. Tell me,
CBI.
the CBI will be prejudiced because of the fact that without that question of law, when you have categorically mentioned on the last occasion to that effect, then you give up on the question of appellant number 1, you are only on appellant number 2. And on the basis of that, I record it in my order and then frame a question of law. Yes,
Yeah,
specific submission.
I do bow down. That
Then,
is,
see-
that is there.
You see,
But-
heard Mr. So they just specific, while hearing, while heard Mr. A. Ganguly, the learned, while hearing the appeal, this court put a specific upon so and so as to whether the seller has any pension rules in respect of so and so. So he said about the pension rules. And to give up on the additional question of law. The learned counsel on behalf of the parties have no in keeping these two documents on record. It has been submitted by Mr. Iganwale, the learned counsel appearing on where the additional substantial question which has been framed on so and so could perhaps not be a substantial question of law involved in the instant appeal. Taking into account the provisions of the Indian Succession Act, do not clearly mention that a child born out of a void marriage may be entitled under the said act. The learned counsel for the appellant, however, submits that the appellant, being the son, would be entitled to family pension in terms with the regulation as inasmuch as from the definition of the child term child in regulation, Iman and family in so and so, the appellant number 2 is entitled to the whole of the pension. He therefore submitted that an additional substantial. This court, having perused the Iman and the Act, does not have a parameter provision similar to and another. It is the opinion of this court appearing on behalf has rightly stated that the additional substantial question which was formulated is not involved in the instant appeal. Be that as it may, this court, taking into account the regulation which is kept on record and marked with the is of the opinion that there is a substantial question of law which can be formulated in terms with so and so. The said substantial reads as under. Now tell me, how do I help you after that order?
But my submission, humble submission remains that, my lord, wife would be covered under that additional substantial question of law. Because what is essentially under challenge herein is that, my lord, the division or appropriation. And the division that has been done, that there will be 7 shares of the pension. That is wrong, my lord, on the part of both the courts below. Now, if the regulations, my lord, which have been considered before your lordship, my lord, that is kept in mind and considered, my lord, then both will be entitled.
Okay, we can take one thing from 6/4/2015. That is a substantial question of law. On that we can develop at best.
It was initially framed by this
But subject to cost upon you.
lordship.
Because this is you,
I
this is
accept.
absolutely
No, I accept. My,
every time you come up with something else.
but lordship, I also consider the second judgment that I have.
What?
Second one.
25,000 as of now.
My lord, I am ready to hear
The
it.
cost.
Because here, my lord, why this judgment, my lord, is necessary, my lord, is that the definition of family, my lords, under the CCS rules, my lord, and who should be considered, though it was in the context of an adopted son, my lords. But the observations of Supreme Court, my lord, in my humble submission will be vital. Lordship, would see para 13 onwards, my lord.
What are you referring to?
No, the lordship kindly sees, my lord, para 21, my lord, because the provision of rule 54 of the CCS pension rules is pari-materia with the regulation, my lord, with which we are confronted here, my lord. The lordship sees para 21, rule 54, this part, deals inter alia with the amount of family pension payable and the procedure to be followed for payment thereof. Rule 54 14B, which is relevant to the present case, defines family for the purpose of Rule 54 in the following terms. You know, the definition is almost same, which is there in the present regulation. And my lord, the Supreme Court, my lord, if I may take a lordship to para 30.
This is for the case of the child.
Yes, but my lord,
Another aspect one can very well draw in
Good.
from this is that this particular woman will be the appellant number one, was a dependent upon the wife, upon the person concerned during his lifetime. And as such, he therefore would be entitled to.
Good.
She would therefore would be entitled to, taking into account the scope of the family
pension.
that one can
That is
draw it.
because
Because
this-
here the case is as to whether the son of a widow,
Yes.
or a widow having
adopted as
adopted the son would become within the ambit of
yes.
family to get the family pension. The Supreme Court said no.
No, so there has
And
to be a
further
nexus.
distinguish a posthumous son to that of a son being adopted by the widow.
After the death of the government service.
Obviously, when I'm saying widow means
Oh,
after
okay.
the death.
That is and my lord, the Supreme Court has specifically used the term, my lord, familial relationship.
Hmm?
Familial relationship in para 35, my lord. The lordship sees for
Oh, we are not going to read the judgment of the Supreme Court like a statute.
no, that is there, but you know, all persons who would have had a familial relationship. That is what,
Family means the sisters also have.
no, but
Can
sister,
we extend it then?
no, because my
You
lord,
come
the
up
rule
with
excludes
those
them.
terms.
my lord.
No,
The rule
nothing.
excludes.
I think I have heard you more
Lordship,
than enough.
I, Lord of-
Yes, Mr. How do you come within the scope of the regulation?
My lord, the mother.
Mother did?
No.
Mother elect.
Mother and sister. Yeah, yeah. Now question is that my lord, the sense, marriage is invalid. Marriage is illegal. That is decided by body.
No, it's okay. That will take care of it. I'm not on that. You may not have anything to do. But the question is, can the mother, would the mother come within the ambit of family?
As per regulation,
If it does not come, then the mother has no role.
but if the son is my lord, excluded. Then
Son cannot be excluded. That
Now,
is,
one
therefore you are not on appeal. So therefore the son cannot be excluded.
agree with the shares. Agree with the shares, my lord.
We are only concerned with the pension and the benefits which are flowing from CBI. We are not on the immovable property.
No, only family.
It's only family pension. Well.
Family.
Others,
Therefore, the question is, we have to go as per the family pension rules.
Rules.
Now, how do you bring in the mother within the definition of section
That
2O?
is correct, but we are not, we consider. As per the, my lord, Indian Succession Act, the illegitimate child included from property of the deceased. It is the law. Now, how under the regulation, a illegitimate child can claim the family.
But the regulation is not on challenge.
There is no definition of son, whether legitimate or illegitimate.
The son is there.
Son is there, but
So therefore, they don't give the definition of
of
son, but they give the definition of child.
child includes
Child includes a son.
son.
So therefore, the question is any son.
But whether illegitimate sons can.
So why should we import something which is not there, more particularly when the pension regulations are beneficial?
Indian succession is otherwise say that illegitimate son cannot claim the property of the deceased.
Where is it?
I have referred judgment of this Madras High Court.
No. Don't come up with those type of, unless the Supreme Court says this court is not bound with that.
As well,
Even a coordinate bench also difficult.
Lordship has seen the other judgment of the Supreme Court. Neetu's
He has also given Kerala High Court as well. Not satisfied with
this
those.
judge has not, this judgment.
With due respect.
The judgment has not been overruled by this any court or,
Not necessary, but it is not binding on me.
that is correct.
But the
Otherwise,
son has to be legitimate or not, because the act does not say so.
there is no need that.
The act is although in a particular portion of the act, it has a reference to an illegitimate son.
It is not.
But in respect to the properties, there's no mention at all. It only says that if there is no son, the sister gets it. If there is no lineal descendant,
Unions.
then the sister and the mother
Mother.
gets it. It's 25 or something.
25 laws.
If I'm not wrong. Difficult. That's it. Yes. Main person is him now in view of what he has done.
Reflection will be to make.
No. Your role becomes more because what he has argued today. Otherwise, there was no problem with the role. The role becomes important because what he says is a very important argument also. You see, yes, the wife may be not a proper wife out here as per the law. She may not be a proper wife as per law, taking into account that he remained as a Christian and the marriage took place as a Hindu. But the fact remains that they were cohabiting, which is a finding of fact. Now, once they are already cohabiting, which is a finding of fact, and there has been a long cohabitation, and out of that there is an offspring. They have challenged the marriage. Marriage may not be proper.
Yes, sir.
But the fact remains that there has been a cohabitation and taking into account the beneficial nature of the legislation. Why the appellant number 1 would not be entitled to family pension? You see, the family pension will be one. But what makes the difference is this. The family pension is normally when only the son gets it, it comes to only 25 years. And he's about to get 25 years now. But as regards the wife, it will continue till her death. So therefore, there would be an additional burden on the CBI. Argue.
Your Lordship, my argument is only confined that we are bound by the regulations. And such
Fantastic.
the order passed by Your Lordship that
Chalo.
is only bounding
Let me
to us.
Heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the appellant. Why there are two appeals?
No, there were two suits there, one filed by us, the other filed by the private respondent.
Okay.
Two appeals.
Both the suits common judgment,
No, two different judgments. Two different judgments, sir, which are there.
two different judgments,
Yes, sir.
holding the same thing.
Holding essentially same, sum in substance is that 7 shares were created. One was given to the son, 5 shares of the sister, 5 sisters, and 1 to the mother of the deceased. That is how the division, the appropriation was done.
Okay. Heard Mr. A. Ganguly, the learned counsel appearing on behalf of the appellants. There are two appellants in both the appeals.
Yes.
Appellants in both the appeals. Mr. N. Hawk, who appears on behalf of the respondents in the appeal, and Mr. M. Sharma, the learned counsel who appears for the Central Bank of India.
Yes, sir. Thank you.
Central Bank. I will record one thing. Because of your inefficiency, the matter got delayed. And you write a letter to the Chief Justice.
That I came to.
It
be
is
aware only
drafted
after-
by you only.
Not- sorry, madam.
Even drafted by you only.
No,
Obviously, she would not be in a position to draft it in that manner.
because I have advised.
We understand the language, Mr. Ganguly. And it is absolutely within what you have done because of that. You have not properly paginated everything. I remember that.
Even after pagination, lordship is hard. And in fact, on that day,
Black Book no matter of urgent disposal of Mr. Ganguly henceforth. Last matter to be heard on urgent basis. No.
I brought one.
Take it to a picture. Let I appeal. No matter to be heard on. I'll record it in the order. Will be a judicial order not to lay any more matter of Mr. A. Ganguly before.
Lordship will not deploy it.
Will be happy enough.
No.
Both the appeals are taken up for disposal together, taking into account that in both the appeals, the issues which arise for consideration is one and the same. Arise for consideration as well as the substantial question of law so framed are one and the same. In RSA number 260 of 2014, which is directed against the judgment and decree dated 12/6/2014, passed in title appeal number 15 of 2011, whereby the judgment and decree dated 24/10/2011 passed by the learned Munsif number 1 Punitpur at Tejpur to trial court co-edified, entitled suit number 18 of 2007 was upheld. This court, by an order dated 6/4/2015, framed the following substantial question of law. Order. Next. In RSA number 43 of 2015, which is directed against the judgment and decree dated 12/6/2014, entitled appeal number 14 of 2011, whereby The appeal was dismissed, thereby confirming the judgment and decree passed by the learned court of the Munsif number 1 Tejpur, Punitpur at Tejpur, dated 24/10/2011, in title suit number 2008, number 28 of the 2006. The following substantial question, the learned court in bench of this court had framed the following substantial questions of law. While hearing these appeals, this court had framed an additional substantial question of law on 8/8/2023. Full stop. The same additional substantial question of laws, however, later on, taking into the provisions of the Central Bank of India Employees Pension Regulations 1995, as well as the Central Bank of India Officers Officer Service Regulations 1979, was reframed by an order dated 18/2/2025, which reads as under 18. The question which is involved in both the appeals, the question therefore which arises for this court to adjudicate is as to whether the substantial questions of law are, as to whether the substantial questions of law so formulated are involved in the present appeals. For that purpose, this court finds it relevant to take note of the brief facts which led to the filing of the present appeals. The appellant number 1 and 2 herein the appellant number 1 herein had filed a suit which was registered and numbered as title suit number 28/2006. In the said suit, in the said suit, it was alleged that one Ripul Musahari while posted at Lokra as cashier of the Central Bank of India, the defendant number 1, married the appellant number 1 on 6/3/2000, married the in the said suit, it was alleged that that one Ripul Musahari, while posted at Lokra as a cashier of the Central Bank of India, CBI, married the appellant number 1 on 6/3/2000, as Fishery Kalia Gosai and Namgor, according to religious rites of the Satra, in presence of the father of the appellant number one and local villagers and devotees of Fishery Kalia Gosai Satra. The said Ripul Bosamatari during his lifetime also opened an account, a joint account in the Central Bank of India, bearing account number 4815, wherein the appellant number one was shown as the wife of late Ripul Musahari. Unfortunately, late Ripul Musahari expired on account of a road accident at Balipara on 19/1/2003. The CBI had issued a certificate dated 1/12/2003 admitting the appellant number one's husband, admitting the declaration of the appellant number one's husband as regards the appellant number one's marriage with him and opening of a joint account of the appellant number one and her husband being account number 4815 and the accident involving the death of the appellant of late Ripul Busamatari as stated. It is also pertinent to mention that out of the wedlock of the appellant number one with late Ripul Bosumatari, a child was born on 18/6/2001 at EMM Hospital and Research Center, Tejpur. The appellant number two is the son of the appellant number one and late Ripul Bosumatari. The respondent number two herein was the sister of late Ripul Bosumatari, wrote a letter dated 27/6/2001 asking the appellant number one as well as asking the appellant number one to convert into Christianity and remarry as per the Catholic tradition. The dispute arose when the appellant number one sought for the the service benefits from the CBI and objection raised by the respondent number 2. And under such circumstances, the appellant number 1 filed title suit number 28/2006 seeking a mandatory injunction directing the CBI to settle and pay the family pension to the appellant number 1 and her and the appellant number 2, who are the legal heirs of late Ripul Bosumatari Musayari. It is relevant to take note of that the defendant number 2, the respondent number 2, contested the said suit on the ground by raising various preliminary objections, including the objection as regards non-joinder of necessary parties. The case of the respondent number 2, in her written statement cum counterclaim filed in title suit number 28/2006, is that the appellant number 1 was not the legally wedded, legal married wife of late Ripul Musayari. And apart from denying the marriage which was solemnized with late Ripul Bosumatari on 6/3/2000 at Sri Sri Kolai Gosai, Than Namgor, it was stated that both the appellant number 1 as well as late Ripul Bosumatari Musayari were not followers of Striya religion, Striya religion, custom or usuals. It was mentioned that late Ripul Musayari was a scheduled tribe and cannot adopt cannot adopt Kshatriya religion or custom stiltily without the knowledge of his family or socially, and no proper adoption at all took place. It was also mentioned that the appellant number 1, being an Ahom, could not have adopted Kshatriya religion only for the purpose of marriage. Further to that, it was also mentioned that late Ripul Musayari was a Protestant Christian by religion, and a marriage between a Christian and a non-Christian or between a Christian has to be solemnized according to Indian Christian Marriage Act 1872. And any marriage solemnized otherwise than in accordance with the provisions of the Act would be void in law. Further to that, in the counterclaim so filed by the respondent number 2, it was stated that the respondent number 2, along with her 3 sisters and the mother, were the legal heirs and successors of late Ripul Musahari, and as such sought for appropriate declaration in that regard. It was further mentioned in the said, it was by way of the counterclaim, the respondent number 2 further sought for all the retirement benefits or all the pensionary service benefits, including provident fund, leave salary, job on compassionate grounds, family pensionary benefits, in favor of the respondent number 2, her mother and her 3 sisters. The record further reveals that pursuant to filing of a counterclaim, the respondent number 2 along with her mother and 3 sisters jointly filed another suit, being title suit number 18/07 against the Central Bank of India and the appellant numbers 1 and 2 herein. The said suit, being title suit number 18/2007, appears to be similar. A perusal of title suit number 18/07 shows that the claim made by the respondent number 2, her sisters and her mother were similar to the counterclaim filed in title suit number 28/2006, and the relief so sought for were also the same. The plaintiffs, the appellants herein, contested the said suit by filing the written statement stating inter alia that the appellants herein were the legal heirs of late Ripul Musahari and were entitled to all the service benefits of late Ripul Musahari, as was contended in title suit number 28/2006. Next. In title suit number 28/2006, the learned trial court framed 6 issues which, being relevant, are reproduced hereunder. Page 51 of the or RSA 2000. On behalf of the plaintiff entitled, on behalf of the appellants herein, 3 witnesses were adduced, and as many as 14 documents were exhibited. On behalf of the defendant, on behalf of the respondent number 2 herein, 3 witnesses were examined and 6 documents were exhibited. The learned trial court while deciding the issue number 4, which pertain to as to whether the plaintiff and Sri Rimun Sagar Musairi are the only legal heirs of the deceased of Ripul Bosamatari. Observe that the appellant number 1 was not the legally wedded wife of Ripul Musairi, and as such, she is not the legal heir. However, after arriving at the finding of fact that the appellant number 2 was the biological son of late Ripul Musairi, the learned trial court held that the appellant number 2 was entitled to the share in the self-earned properties, including pension rights of late Ripul Musairi. Paragraph number 19 of the judgment of the learned trial court being relevant, 19 and 20 of the judgment of the learned trial court being relevant, is reproduced hereunder, page 60. Now coming back to the title suit number 18/2007, the learned trial court in the present suit, in this suit, framed as many as 5 issues, which being relevant are reproduced hereunder, page 53 of RSA number 260/2003. On behalf of the plaintiff, in title suit number 18/2077, 2 witnesses were examined and 6 documents were exhibited. On behalf of the defendant, in title suit number 18/2007, who were the appellants in the present appeals, the appellant number 1 was examined as the defendant witness, and she exhibited as many as 1, 14 documents. The learned trial court, by the judgment and decree dated 24 10/2011 also disposed of according to judgment in decree 224. Huh? Or 224. Also disposed of the title suit number 18/2007. Holding inter alia that the appellant number 1 was not the legally wedded wife, but appellant number 2 was entitled to the share in the self-earned properties, including pension rights of the deceased late Ripul Musahari. The relief so granted by the said, the reliefs which were granted in favor of the plaintiffs in title suit number 18/2007 by the learned trial court being relevant is reproduced herein under paragraph number page 62. Paragraph 2. Plaintiff is entitled to A and B. Because being agreed, 2 appeals thereafter, two appeals were prepared by the appellants herein, which were registered and numbered as title appeal number 14/2011 and title appeal number 15/2011 before the court of the civil judge at Tezpur, hereinafter referred to as the learned first appellate court. By separate judgments, the learned first appellate court, by separate judgments dated 12/6/2014, the learned first appellate court dismissed both the appeals, thereby confirming the judgment and decree passed by the learned trial court, both dated 24/10/2011 in title suit number 28/06 and title suit number 18/2007. It is against these two judgments passed by the learned first appellate court the present appeals. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties and heard on the substantive questions of law which have been formulated by this court. First, the substantial questions of law on 6/5/2015, the learned coordinate bench of this court had formulated identical substantial questions of law in both the appeals. However, in RSC numbers 43/2015, as stated above, an additional substantial question of law was formulated. Let this court, therefore, first look into as to whether the additional substantial question of law which was framed on 6/4/2015 entitled in RSC number 43/2015 is involved in the instant appeal. Good. আগত এতিয়া আছে, huh? The said additional substantial question of law. The said substantial question of law. So formulate is as under. What do you have to say on order 1 rule 8?
In the C2 file, my lord, there is one petition, my lord, which was actually filed, which the learned trial court failed to consider, is that there was a petition number 2062 oblique 2006.
But whether the application under order 1 rule 8 was allowed?
Yes, it was allowed. And there was
Did you go for publication?
no, not publication. No. That petition was, my lord, for treating the mother and sisters of the defendant number 2 in a
What is
representative.
order 1 rule 8?
My lord,
Order 1 rule 8 is like a more like a public interest litigation.
yes, in a representative
Says
capacity.
that, yes, that I file a suit on a representative
Yes.
status. And anybody, if anybody has anything to say, he can come up and say. But for that, you have to issue a notice.
My lord.
Pursuant to- Did you do that?
No, that was not done, my lord.
So if that is not that, order 1 rule 8 doesn't have any relation here.
No, no relation. And that petition was
So
specifically
therefore, the
allowed.
question, when the formalities as per order 1 rule 8 has not been done, no order have been passed. Has any order been passed?
Yes, my lord. There is an order passed
But
on
did you carry it out?
24/01/2007.
In which suit?
My lord, that is in the C2 file of the LCR. My lord.
Which
There is a C2 file, pages 43, 44.
28. It will be in 28.
It was filed, my lord, on 6/7/2006.
Where is that order 1 ruling?
Not 43, 44, as per my noting.
Huh?
Page 43, 44 of the C2 file.
Which file?
C2 file of the LCR. my lord. They probably. The LCR, my lord, there is a C2 file.
It too.
Pages 43, 44.
It too is different.
No, 43, 44. Petition number is 2062 of 2006.
43 is different. Okay, let me come back.
Judge.
You just find it out. I don't think so.
There was an
No,
order.
when there is no order, you see, you have to do it at the time before initiation of it, but there is no order out here.
There is an order, my lord, which allowing that petition.
Huh?
There is an order allowing that petition. In fact, on
When was it allowed?
Lord 24/1/2007. And by the same order, the counter.
No, whose suit?
My lord, this is TS 28 of 2006.
24?
No, 28 of 2006.
No,
My suit.
24?
My suit.
What is the date on which it was allowed?
Order is dated, my lord, 24/1/2007. No objection was filed by the defendant number.
No, 24/1/2007 is excluding this, this counterclaim.
But two separate orders were passed on the same day.
I have already heard, peruse the case record and so in the Nima counterclaim area in the state and so. I find that the counterclaim order is not maintainable. Seeing petition of the plaintiff with the prayer to treat the minor son as plaintiff who nominee and so and so. This cannot be order 1 rule 8.
That is only.
Huh. Mister.
Rightly or wrongly, that is.
Exactly, encourages type of whatever you feel like you do it, nah?
That,
How does order one rule eight means sometimes I think when a CPC has gone for a year, means whether this CPC is what I am following or you have a different CPC. We'll read what is order one rule eight after.
May I please, Your Lordship? Your Lordship, may I be allowed to take a leave, Your Lordship?
This court have duly taken note of order one rule eight of the Code of Civil Procedure 1908 for short, the court. Perusal of the said provision shows that where there are numerous persons having the same interest in one suit, one or more of such persons may, with the permission of the court, sue or be sued, or may defend such suit on behalf of or for the benefit of all persons so interested. Or the court may direct that one or more of such person may sue or be sued, or may defend such suit on behalf of or for the benefit of all persons so interested. However, in order to take the benefit of the said permission or the direction to be passed by the court in terms with sub-rule 1 of rule order 1 rule 8, there is a requirement that the court, in every case where such a permission or direction is given, should give notice of the institution of the suit to all persons so interested, either by personal service or where by reason of number of person or any other cause such service is not reasonably practicable, by public advertisement as the court in each case may direct. In the instant proceedings, a reference has been made in the instant proceedings, the learned counsel appearing on behalf of the appellant to the attention of the court in the order dated 24/1/2007, passed in title suit number 28 of the 07.
six, 2006.
A perusal of the said order, so passed by the learned trial court, does not show that the mandate of sub-rule 2 of order 1 rule 8 have been adhered to. And under such circumstances, it is the opinion of the court that the substantial question of law so formulated by the learned coordinate bench of this court, above substantial question of law so formulated by the learned coordinate bench of this court on 6/4/2015, cannot be said to be involved in the present appeal. Let this court now take up the substantial question of the other substantial question of law, which is common in both the appeals. Which was formulated by the learned coordinate bench of this court on 6/4/2015. The said substantial question of law reads as under. This court had duly taken note of the decision in respect to issue number 4 in both the suits. Passed by the learned trial court as well as the learned first appellate court. The learned, it appears from the findings of facts so arrived at it appears from the findings of facts as well as the observations made therein that the learned first appellate trial court as well as the learned first appellate court were swayed by the provisions of the Indian Christian Act 1872. But without taking into consideration the that the suits so filed by both the parties were in relation to the entitlement pertaining to the service benefits of late Ripul Musari upon his demise. Both the courts below failed to take into consideration the Central Bank of India (Employees Pension Regulations 1995). For short, the regulations of 1995, which were holding the field as regards the entitlement of the family pension and other benefits. Under such circumstances, it is therefore the opinion of this court that the substantial question of law so involved, so formulated by the learned coordinate bench of this court dated 6/4/2015 is involved in the present appeal. Let this court now take up the additional substantial question of law which was formulated by this court by the order dated 18/2/2025, which reads as under. Next. It has been submitted at the bar that the only question which arises, only entitlement which the parties, which the appellants or the respondents herein would be entitled to. Respondent number 2 herein would be entitled to is the family pension. In as much as all other benefits have already been appropriated by the Central Bank of India, CBI, towards certain dues payable against the loan taken by late Ripul Musari during his lifetime, isn't it? Under such circumstances, it is therefore essential to deal with the question only as regards the family pension. The Supreme Court, in the case of Punammal versus Union of India, reported in 1985 3 SCC 345, had the occasion to deal with the purpose for which the family pension is granted. Paragraph 3 of the said judgment being relevant is reproduced hereunder. A perusal of the above quoted paragraph would show that the family pension was devised as a means to help the dependents of the deceased government servant to tide over the crisis and to extend them some succor, SUCCOUR. Therefore, from the very definition of the term family, has to be deemed to include only those persons who were dependents of the government servant at the time of his death. The materials on record clearly show that both the appellants were dependents of late Ripul Musairi at the time of his death. In the above perspective, let this court now take note of the regulation of 1995. Regulation 2G defines the term child, which being relevant is reproduced hereunder. The above quoted definition, therefore, brings within above quoted definition applied to the facts of the instant case would show that the appellant number 2, who is admittedly the biological son of late Ripul Musairi, would be considered as a child within the definition of regulation 2G till he attains 25 years of age. Regulation 2O. Regulation 2O defines the term family, which being relevant is reproduced hereunder. From a perusal of the above, it will be seen that the wife of a male employee or a husband, that from the above quoted provision, it will be seen that a wife of a male employee would come within the definition of family. Similarly, a son or a daughter until they attain the age of 25 years. Similarly, a son until he attains the age of 25 years would also come within the ambit of a family. The mother would also come within the ambit of the family, subject to the deceased not leaving behind a wife, a widow, or a child. Therefore, from the above definition, it is clear that the respondent number 2 or her sisters would not come within the ambit, within the meaning of the family as defined in Regulation 2O of the Regulations of 1995. The mother of the respondent number 2, who is also the mother of late Ripul Musari, would have come had there been no wife, no widow, or a son or a child of late Ripul Musari. The findings of fact categorically show that the appellant number 2 is the biological son of late Ripul Musari. The regulations of 1995 also do not distinguish a child who is born, a child, whether legitimate or illegitimate. Under such circumstances, as there is a child born, there is the child of late Ripul Musari, the question of the mother of the child, the mother of late Ripul Musari coming within the ambit of family, within the ambit of the meaning of family as defined under 2O of the regulations of 1995 does not arise. Now the question also arises. Under such circumstances, the additional substantial question of law which have been framed on 18/2/2025 is involved in the instant appeal. Next. This court further finds it pertinent also to take note of that for the purpose of the regulations of 1995, it does not distinguish 1995 to come within the ambit of a family a person ambit of a family, the wife of a male employee. Find it relevant to observe that Regulation 2OA categorically observes that a wife of a male employee would come within the ambit of a family. At this stage, this court finds it pertinent to take note of that the findings of facts so arrived at on the basis of evidence is clear to that effect that the appellant number one cohabited with late Ripul Bosumotari, and out of their wedlock, the appellant number two was born. The learned trial court, as well as the learned trial first appellate court, went into the question as to whether the marriage was legally valid in terms with the Indian Christian Marriage Act, but did not address the point as to whether, for the purpose of pension or the pensionary benefits, the appellant number two, one, would be entitled to the family pension. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Srimati Shira Mabai, wife of Kundalik Bhabi, where not reported in SCC.
I think it is, but I do not have this citation. But SCR and INSC.
Cost of 25,000 has gone to 35. And it's relevant to take note of the judgment of the Supreme Court in the case of Shira Mibai, SISHIRAMEBAI versus Record Officer for OIC Records, reported in 2023 SCC Online SC 1026, wherein the Supreme Court was dealing with the question as to whether a person, whether the person who was married during the existence of a valid marriage would be entitled to marry, where a person who was married during the existence of a valid marriage and subsequent to the decree of dissolution of the first marriage would be entitled to the benefit of the family pension. observations of the Supreme Court. At paragraph number 14, 15, 16, 17, 18, 19, 20, 21, 22, and 23 makes it very clear that there is a presumption in favor of a marriage when a man and a woman have continuously cohabited for a long spell. It was further observed that when there is circumstances that weaken such presumption, court ought not to ignore it. The burden lies heavily on the party who seeks to question the cohabitation and deprive the relationship of a legal sanctity. Thus, taking into account this court finds it relevant to reproduce paragraphs 14 to 23 of the said judgment hereunder. Next. In the instant case, it would be seen that the fact that the petitioner, the appellant number 1, married with late Ripul Musairi, is not in doubt, as would be available from the findings of fact. The only question is as to whether the marriage was the finding of fact. However, both the learned trial court as well as the first appellate court rejected the marriage on the ground that it was not done so in terms with Section 4 of the Indian Christian Marriage Act, 1872. But the fact that the appellant number 1 was married to the respondent number to late Ripul Musamatari, and out of their wedlock a child was born, is a fact which is duly admitted, is apparent from the records. Under such circumstances, it is therefore the opinion of the court that for the purpose of family pension, the appellant number 1 can be deemed to be the wife of late Rimkul Dosumatari. And as such, the appellant number 1 along with the appellant number 2 would be entitled to the family pension where is that provision, family pension?
Not the regulations.
Huh?
In
Family
in the
pension?
regulations.
Where is the provision of the regulation?
Will be at 39.
Huh?
39.
59
39 is
of
regarding
the regulation.
no. Yes, regulation 39. The 95 resolution.
Be entitled to family pension in terms with chapter Roman 7 of the regulations of 1995. So accordingly, this court therefore disposes of both the appeals with the following observations and directions. Number 1. The judgment and decree passed by the learned first appellate court, dated so and so in appeal number so and so are set aside and quashed. Number 2. The appellant's herein would be entitled to family pension in terms with chapter 7 of the Central Bank of India bracket Employees Pension Regulation 1995. Next. The Central Bank of India, who is the respondent number 1 in both the appeals, are directed to do the needful in terms with the said regulations of 1995. Next. Yeah, both the appeals accordingly stands disposed. The registry is directed to draw up a decree in terms of paragraph 1, 2, in terms with paragraph number so and so, in terms with the observations and directions given in paragraph number so and so and so. Next. Return to records. Any urgent matters not to be.
Because I'm deeply obliged for the Lordship's patient hearings in this matter, Malad, for so many days.
I think, Mr. Hawk, the reason was not for anything else. This fight could have ended long time back. This shouldn't have. It was a very sad thing. From 2005 onwards, it shouldn't have. The only reason was she did not convert. That seems to be the apparent reason why it happened. She had converted then, at the time of the marriage, everything would have happened. Very sad.
Deeply obliged.
Item 428.
Yes. Mr. Botako, did you find anything?
I don't. The Lordship, we have found the procedure. We filed an additional affidavit in the matter.
The file?
Yes, Your Lordship. Its flag mark is C. The procedure is given in Schedule 2 in page number 363. There will be the procedure.
December वाला, that 2015 वाला notification.
Yes,
Yes.
have you filed the this EM or not?
I have filed.
When?
Last time I filed immediately after I started. I mean, before I started.
No,
After that.
after the MSME Act came in,
Yes,
did
I
you
filed.
file it?
I filed it.
When? That is not
Annexure,
there in
annexure
your-
4.
Huh?
Annexure 4 of my
Oh,
page 57
your writ petition.
of my writ petition. 57. Write this first. Page 57, annexure 4.
It's okay. So you filed in the year 2014.
14, right.
2014. Okay, when did you make the supply?
Lordship, I just give a chart. Where's the chart? It was during the when the okay. Yes, Lordship, I have given a detail of the sub work order at page 13.
Page?
Page 13. That MSME the supply, the date, the work order, and the MSME registration, relevant MSME registration extension over there. Everything is good.
This is for this case.
This
There are other cases.
others also we have the same thing. But anyway, I may just point out to your lordship. In fact, the government of India has also issued a notification that we all have registrations. I'm not on that. We are duly registered. We have filed a part 2. I mean, that is not the issue. But now the entire filing of ME part 2 has been relaxed by a notification by the government of India. They say that this is more a beneficial. It's not a regulatory.
No, the 120 days which was given on 8/1.
That has been done.
That has been said that it is relaxed and
Relaxed.
it is more of a regulatory.
Yes.
Therefore, it gets.
It's not regulatory.
But anyway, you had it in the year 2014.
We had in all the cases we
You
have.
had that. You have duly submitted that.
Yes,
So therefore, that is there. Now the question is that they are to pay interest.
interest, and which they have admitted in their affidavits. Up to 2019, they have filed their affidavits where they have given the account statement, that's the department, and they admit that this much interest, this much principal, and this much interest we have to pay 2019. In fact, in 2019, in respect of the central schemes, they also made us sign a memorandum of understanding where they had bargained with us, told us that, see, you take interest up to 31st of March as far as the central scheme is concerned, 2019, and rest we will not pay, and we'll pay you the principal. So after much delay, they paid us the principal, but even those undertakings are there. And Lordship, the important, interesting part is that a bunch of people file, their companies file petitions for this exactly non-payment of the MSME interest and principal. The department, what they did, and after the order was passed, court said you consider, do the needful. That was the order passed by the court within a period of 3 months. They did not do anything, so again we came up in contact. So a few of the suppliers were handpicked by the department. There was a whole bunch, even I was one of them. Few was handpicked and substantial amount of interest was paid to them. No questions asked. I mean, on their admission, they have some amount due, but nevertheless,
They like the color of the skin.
probably, and Lordship, I gave a chart. As many as 9 were picked, and they were paid interest in crores. Of course, which was due to them. I don't
So
say
how much are you entitled to in these three? Three repetitions remain.
3 repetitions today. So, Lordship, as per, let it must go by their statement. We are not disputing their calculation is at page 159, which they filed by affidavit on affidavit 159.
2 crore. How much?
159.
Ah.
Here they say interest is 4 crores 55 to be paid.
4
4 crores
crores,
55
55
lakh.
lakh 79,715. This is the interest.
They are just calculated up to November 2020.
Oh, they have not paid the principal.
After your lordship's order, they have paid.
Paid the 62 lakhs.
They paid after your lordship had passed an order to pay the principal, they paid. Till November, the interest which they calculated was there. This is not my calculation, they calculated, and it comes on their affidavit.
Total is 455
450.
minus 62.
No, 62 is the principal.
Huh?
This is interest.
No.
Yes, lordship.
Principal amount state sector 62.
60, that has been paid now.
Total fund paid 0. Balance 62. So total remain to be paid 455. So minus 60.
No, 62 is principal, 455 is the interest.
No. Is it paid?
Lordship will look at the balance is 62 lakhs, that is the principal.
Okay. So interest amount is only 455.
4 lakh 55, that is separate.
Government of India have had
Lot of money they have, Lordship.
ever too much.
That is up to
Any-
22, 20.
This is two peanuts, and now it has become how much?
Now
8 crores.
we have left the calculation to the government because we don't want to dispute. Let them calculate, let them give, let them do that exercise.
8 crores,
Maybe because this was paid only this year.
5 years.
I don't, from EAT department, whatever was admitted as the principal amount, that has been paid.
That we are not disputing.
That you have paid after orders being
Orders from the
otherwise you
court.
didn't pay. And that stopped the interest. That is the good thing which I have done. Public money. Now, as regards the interest you pay, you have a lot of money. PHE has lots of money.
For interest,
Finance has lots and lots of money. You can spend money like anything.
Now Lordship, they will say, I know what they're going to say. Now there's a new plea which they come up with. First is, you're not an MSME. You don't have a registration, which we have proved them to be wrong, Lordship, on record. Now they want to say that you have to go under Section 18. Why? The Section 18 of the MSME Act is applicable only if there's a dispute to the amount. These are the two grounds they have taken. Lordship will look at the Section 16. When any buyer fails to make payment of the amount to the supplier as required under Section 15, the buyer shall, notwithstanding anything contained in agreement between the buyer and the supplier, or any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on the amount from the appointed day, or as the case may be, from the date of immediately following the date of agreement upon 3 times of the bank rate notified by the Reserve Bank. Now, Lordship comes to Section 70. For any goods supplied or services rendered by the supplier, the buyer shall be liable to pay the amount with interest thereon as provided under section 16. Now Lordship comes to section 18. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute which may, with regard to any amount due under section 17, is regard to the amount due. So, Lordship, I am not disputing the amount. Only then the question of going to the felicitation council will arise. I am not disputing the amount. Let them calculate. Even after 2020, let them calculate. Dispute I'll not. So this is what they want to say. Why will I go to a felicitation?
So they want that you to go to the MSME Enterprise Facilitation Council,
Huh.
then get an order from there,
Why not?
and again come out here.
Again, come again, so that they can delay it further. In fact, in this case,
Or
I
taking into account that there shall be no interest on interest. Pay of the-
Lordship, in fact, in this case, the court had page 140, the MSME had directed them to pay.
Are they not showing this in their budget? These are amounts which are being pending to be paid since long. You must be showing it in your budgets.
Only the principal component was showing. This is why,
Are you saying that you are not showing it in the budget?
but interest, my lord, they will have to have an award from the facility.
Why?
Under the scheme of this act, my lord. My lord, you
Okay,
see the
so are you denying the interest?
interest
So
we are
that's
denying.
the applicable. The fact that these are facts. You, in pursuant to a particular work order, you were liable to pay them this particular amount. The fact that you have paid them the principal means that you were liable to pay, you admit the liability of payment of the principal. Now, once you have to pay, as per the act, you are to pay within a particular period of time. And the act further mentions that if you are liable to pay within a particular period of time, if you don't pay, then you are liable to pay interest. These facts are all admitted. Now you want that this matter should go to them and then again come back to you. Show me a good reason why. Unless you dispute the principal amount.
Because
Without disputing the principal amount, you cannot. Matter ends there. You have to dispute the principal amount. If you don't, no way.
if my lord looks at section 15 of the MSME Act.
Yes.
15 says, my lord, liability of buyer to make payment. Where any supplier supplies any goods or renders any services to any buyer, the buyer shall make payment thereon or on or before the date agreed upon between him and the supplier in writing, or where there is no agreement in this behalf before the appointment date, provided that in no case the period agreed upon the supplier and the buyer in writing shall exceed 45 days from the date of acceptance or the date of deemed acceptance. Section
Acceptance means the acceptance of the supply.
Section 16, madam, date from which and rate
So
and
by section 15, whatever may be the question, from the date they have supplied you the quantity, within 45 days, if you don't, you have to pay. You are given a window of 45.
then, my lord, we have 17, which says
16.
yes, 16 says date
Which is the bone of contention.
date from which and rate at which interest is payable. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force be liable to pay compound interest with uh, monthly rest to the supplier on that amount from the appointed date or as the case may be from the date immediately following the date agreed upon at 3 times of the bank rate notified by the Reserve Bank. Then, my lord, 17.
16. Explain.
16 says when it will be. So it will require, my lord, a determination of the agreement, my lord. Terms of the agreement, when exactly.
No. It says that notwithstanding anything and any other law in time bring it. So you may even it outs the contractor. Outs the contractor insofar as if it is 16 comes into the picture. Because here says notwithstanding anything contained in any agreement between the years. So if you may say tomorrow that you may have a particular, we'll pay you after 45 days or when we get the amount, that is not going. You are to pay within 45 days. And if you don't pay, then you have to pay compounding with monthly rates. Means every month there will be the accumulation of debt. So the amount which is just, for example, 100 rupees into 10% is the interest. Every month it will be with 10% money interest, so yearly interest will become to 101 rupees per month. Because it will be 110 for the whole year, 101 rupees. 101 rupees is the fare, then the next month you have to do it at 101 that. So that would be the compounded interest.
Then, my lord, we have section 17, recovery of amount due. How do we recover, my lord? That process is for any goods supplied or services rendered by the supplier, the buyer shall be liable to pay amount with interest thereon as provided under section 16.
So this is recovery means it gives you the entitlement
Yes.
by statute and entitlement.
This is where the right of interest accrues, my lord.
No, the right of everything includes by statute has been given to them.
Yes, my lord.
A right has been created. Now,
Then, my lord, next provision is important. Reference to micro and small enterprises facilitation council. Notwithstanding anything contained in any other law or time being enforced, any party to a dispute may, with regard to any amount due under section 17, my lord. So it has a connection with section 17, which has a connection, my lord, with section 16, which also has a connection with 50.
who is raising the dispute? Are you raising a dispute?
Dispute with regard to interest, my lord.
Interest, you are raising a dispute.
Yes.
Where is it? How much you were saying that they are entitled?
In the speaking order, my lord, we have
Let us see what is the speaking order. Dated
It was page 287.
to
287. No, they don't dispute the interest. They question my MSME eligibility, not my interest, not the quantum of interest.
So at page 280.
Yes.
Now as directed, let us read it together.
Now, as directed by the Honorable Court, by the order dated 5/9/2018, passed in WP3 so and so, passed in contempt case so and so, the representation dated 9/7/2018 of Guard Poly Industries is taken up for consideration. Upon perusal of the said representation and all the connected records, MS Guard Poly Industries is not found to be entitled to any additional interest in view of the memorandum of understanding dated 14/5/2019.
Okay, now let us come to 14.5. Where is that?
Page number 102.
Page number 109, Lord.
10. Government has agreed to pay to the company the sums due under the terms of the agreement. The final principal amount under year head of 12 is due for payment as on 14/5/2019 under the head 12. Order and amount as calculated up to 12 so is payable by the department for interest to the company firm. Now the memorandum has agreed to pay the entire principal amount of financial by a one-time payment. Both the parties in consideration of the payment of the principal as per A above and agreed to full settlement of the principal amount due under the head 12 and AI is agreed upon not claiming the interest under the head NDRB beyond 12 in witness. But that is only for NRDB,
And that is,
which is only in respect to the central sector,
yes, Lord.
not for the state sector. How do you bring this document?
But my lord, besides this also,
No, besides, no, let us come one by one. So, madam has asked for setting aside this picking order, na? Are you not asked?
Yes, Lord.
Yes. So, first ground on this goes, because this is only for the NDRB. Okay. So, there we come. Now, let us come. So, first person is gone. Now, let us see the second at 2 p.m. after you have a good satisfying.
2 p.m., Lordship.
Yeah.
At 2 p.m.
Obviously, not. Now, let's come to the second. Question is as regards the second aspect, whether they had the EM as on the date on which you issued the work order. Because by operation of law, they get the benefit.
with lordship, I would like to go back to the first issue, my lord, that first issue of when do the MSME status arrive at? In section 8, my lord,
Section
section 8, my lord, next part, provided that any person who, before the commencement of this act, established that a small scale industry and obtain the registration certificate may at his discretion and an industry engage in the manufacture or production of goods pertaining to any industry as specified in the first schedule to the Industries Act 1951, but not exceeding 10 crore rupees in pursuance of the notification of the Government of India in the erstwhile Ministry of Industries dated so and so, filed an Industrial Entrepreneurs Memorandum. Then, my lord, shall within 180 days from the commencement of this act files the memorandum in accordance with the provisions of this act. Now, if a minor sees the annexure at page 57, my lord, which
Yes.
which has been relied dating back to 2014, my lord may see at the top heading EM part 2. It is an entrepreneur's memorandum, not a memorandum, my lord, under this act, because this act had said that those who have entrepreneur's memorandum, my lord, within 180 days shall file a memorandum in accordance with this act. And my lord may see this memorandum does not make any reference to the MSME Act 2006, and neither does it use the word micro, small, or medium. None of those words can be seen, my lord. Only it says has filed a memorandum for a manufacturing enterprise.
Here it says the category of enterprise is small.
Regardless, my lord, it is an EM, not a memorandum under this act, because this act has said those who have EM need to file a memorandum in accordance with this act.
So this is after the coming into effect of the act.
After the effect of the
Kindly
act,
come to the 8.3.
authority with which the memorandum shall be filed by a medium enterprise shall be as may be specified by,
But this is for medium.
this is for medium.
And an industry engaged in the manufacture and so and so, doing investment of plant of more than 1 crore, but not exceeding 10 crores in Iman shall file an industrial entrepreneurs memorandum. Shall within 180 days from the date of commencement of this act. Now, you kindly come to the additional affidavit which has been filed by them. Come to this notification, annexure 8347. And come to 363. First come to 346. You have not been given a copy?
Given a copy. We have same copy. I'll give you. The same copy.
347. In exercise of the powers under subsection 8. Referred to here, the central government, after obtaining recommendation from Iman, hereby provide for format of memorandum and procedure of filing and the other matters incidental thereto for the purpose of the act. Entrepreneurs for meanwhile setting up of so and so. Memorandum is to be filed with the district industry center by a micro, small or medium industry as the case may be under the subsection 1 of section Iman. 4 copies are to be filed. Now kindly come to 367. Last week. The procedure which is being given. And kindly come to 364. Before that, come to 363. Number 3, the district industry centers shall fill all the codes in the form of the memorandum and issue an acknowledgement. After allotting an entrepreneurship memorandum number, date, issue, category of unit within 5 days of the receipt of the form of memorandum by post or same day. If the form of memorandum is submitted in person as well as online. Before issuing the acknowledgement, the district industry shall make sure that the form is complete in all respects. And particularly the form is signed and is accompanied with an undertaking which is a part of the form of entrepreneur's memorandum. Now this is part 1. Now important you see. Number 6, the district industry shall maintain records of all entrepreneur memorandums so filed in respect to the medium industries engaged in production of so and so, and entrepreneur with entrepreneur number allotted to small industries service units, institute of so and so. The form of memorandum is in 2 parts. Any person who intends to establish a micro, small or engaged in providing or rendering service may file, or those who want to establish medium engaged in production of so and so shall file part 1 of entrepreneur in the district industry. Once the above industries start production or start providing the or rendering service, they shall file part 2 of entrepreneur to the district. In case of non-filing of year within 2 years, it will be non-valid. In case of change and so, shall now you come to page 57 again.
Yes.
This is EM part 2, meaning thereby they have duly complied by 2014. Answer whatever you have prepared.
So this document
I sent the copy, see in the other place, exactly the same copy.
Huh?
It's
Uh,
exactly the same.
I had the soft copy, but my lord, I could not connect these, my lord. Now,
Copies
now
were-
it makes sense, my lord. That is
In
established.
3 cases I've served copies.
So this is how it is. So as on 2014, 1T 2014, they had the EM part. Once they have the EM part 2, your second ground on which your speaking order lies is bad. Now the third ground which you are saying, go to the facilitation tax. Would it make any sense for this court now to send them to facilitation where there is no dispute? Where is the dispute for this court to send them to facilitation?
Because my lord, when the petitioner, for my lord,
The best
Under the-
one would be
Yes.
try to negotiate and finish it off. Isn't it? If they come down, because if you get an order from the court, it will be much more. What do you think? You'll have a more heavens will fall upon the state finances, although the finance of the state has no problem. Finance department has got problem.
but my lord, either they
The
get.
only
yes.
worry, Mr. Kotakur, is this. You are aware that whether they disclose as MSME or not is not necessary. The preferential policy which has come up in the year 2021 is on regard to certain benefits being given as regard earnest money and all these criteria and all this. But by way of a statute, they have been given the benefit of an interest. How do you take care of that? And by section 17, if I'm not 17, the entitlement has been fixed as regards 16. So therefore, a right is being created and that right is being denied by you. If this gives the court the power to exercise a writ in the nature for complying with the duty.
But in my opinion, my lord, it will be half application of the MSME Act, because section 17 is again, my lord, connected to 18, which tells us that for any claim of dispute, they may approach the MSME council. Then, my lord, in the next provision, there is a provision for setting aside that award, which says if you want to set aside award, 75% of the amount will have to be deposited, my lord. So that entire process, my lord, has been laid down. And when they came here under the equity jurisdiction of this honorable court, my lord, we made a determination as to what was our admitted amount. And accordingly, my lord, we determined that. And of course, my lord, there was delay. We could have done it much earlier. It took some time, man. But eventually it was paid, the admitted amount, my lord. So,
But with the
Principal
moment,
amount.
yes, by that speaking order, there is a dispute being created as regards non-payment of an interest. You say your thing is that the moment we pass a speaking order, a dispute is being created. Now, when the facts are already admitted, these facts are admitted. Fact that there was they are an MSME, an admitted fact. The fact that they are entitled in terms of the benefits under this act is an admitted fact. It means you don't need to go into anything. The fact that you have made a dispute by passing a speaking order, this court has the power to look into as to whether the speaking order has been rightly done or wrongly done on the basis of on the facts which are already there, without rendering them to go to any other proceedings. The moment I set aside the speaking order, what remains then? Your entitlement, the amount which you have paid at 62 lakh, or what, would then become a part of the interest, taking into account that the interest has to be first apportioned before the principal, which means the principal still remains out of the, because the concept of payment of a principal is not there. So therefore, this could pass that order as an interim that you pay the principal. But the moment I set aside the order, then the payment of the principal which is given, which you have paid, cannot be treated as principal. It will be apportioned first towards the interest. Then your principal remains, along with the accruing of interest, which may be more bad. Because that I have to do it. Because then they will let them go to the facilitation center, but the principal remains. And there will be continuous accruing of the interest. So this court cannot do it.
but that is the submission, my lord, that if the act has to be applied, my lord, it has to be applied in totality, my lord. Otherwise it is just the equity jurisdiction where it was asked what we had admitted, my lord, and we had paid what we had admitted. That is how.
You paid after the court passed the order. You didn't.
Who
You
was
said
so
that whenever we get the funds, we'll pay. On the basis thereof, it is saying that you have violated the gone contrary to the mandate of the MSME Act. The question is, there are two faults. One, as regards the speaking order, has two aspects. The first is as regards not find to be entitled to any additional interest in respect to NDRB. They are not claiming that. Are you claiming? No.
Lordship, up to 19, they promised to pay.
No, you are not claiming any additional interest on
Additionally,
this.
we are not. We are getting only what they offer.
On this amount pertaining to the NDRFB. That amount which is there, na?
Additionally, we don't have any
Under
additional
the
thing.
NRDWP. You are not
That is-
claiming.
No,
You are not claiming on that. So the only question is they are claiming additional interest or interest on the 62 lakhs component, which you admit that you are entitled, they are entitled to. The moment I hold that they are entitled as per the MSCB matter,
Lordship, may I just point the affidavit which was filed by them? And in fact, we based our writ petition on their admission initially. And the affidavit at 157, 153. Lordship, I don't know how they can keep on changing stance, especially the state government. One. It just so that makes everything clear. That is an affidavit which was filed by the PhD department, who is the chief engineer.
what do they say?
What they say, Lordship will come at page 156, at paragraph 7, that it is stated that as per the proposal of 2 crores, this has been proposed to meet the liability against the state and NDRS scheme. Additionally, 10% state machine matching share, which has to be brought by the state government. Under this head, under this chart head, an amount of rupees 941 lakhs has been proposed for the payment of outstanding principal amount against various court contempt cases. An amount of rupees for 45 54.82381 lakhs has been proposed under the head. This is the amount which is due to me for payment of the outstanding interest against various court and cases. Lordship, they have annexed a chart at page
This is
159.
the amount what? It is a huge amount. All of it. It will
All
come
of
to
the cases combined.
45 crores 54 lakhs.
All of the cases combined. All of the cases combined. They do not dispute. They do not say.
But that doesn't mean that anything has to do.
They do not dispute. They admit. They give the chart. Just one point. Positive fact. Positive fact. All they say is that because of positive fund, we have not been able to pay. One moment. Lordship, at page 145, there's one more affidavit. They say, paragraph 4, however, due to unavailability of fund, payments against the interest portion could not be made, which shall be made as and when the funds are made available. As is paid, this court may please to grant further time. Again, in this affidavit, they admit, and annexure A is again the amount which they have shown. 2-3 affidavits they filed where they admit, and they say that only because of positive fund we have not been able to pay. Here is specific my amount. And we are not disputing this amount.
Now, madam, let us see the contract act,
Lordship?
section 61.
Okay. But this act is not notwithstanding
No,
contract.
no. You have to take care of your payment of the interest principal, na?
Hmm.
Let us send him you to there, to the facilitation there, and say that the 60 will apply. Let them go ahead. Application of payment where debt to be discharged is not indicated. Where the debt has been omitted to debtor has as there is no other circumstance indicated in which the payment is to be applied, the creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor, whether it is recovery is or is not barred by law in force for the time being in it. Application of payment when neither party appropriate. When neither party makes any appropriation, the payment shall be applied in discharge of the debt in order of time, whether they are or not there. If the debts are equal to standing 59 application where a debt is to be discharged. Where a debtor owing several distinct debts to one person makes the payment to him either in with express intimation or under circumstance apply. Payment is to be applied to the discharge there. The payment is itself must be applied. So we do one thing. We apply this 62 lakh towards the and then send you to the facilitation and find it out how much more you.
Lordship, yeah,
No, they want to do it at their own peril. Go ahead. They are only buying time, but you are buying time at 18%. Are you understanding that? You are not understanding it will have a far-reaching consequence. I ask you to therefore settle the matter for the time.
Lord,
But
Lord,
if you don't do it, the problem is there will be a huge problem. I'm saying that what submission you are making it. The moment I say that the debt is first apportioned towards the interest, this 62 lakh, it's towards the interest, then the interest remains. And it will then be continuously, the interest will, there is already an interest accumulated. So out of 4 crore 55 lakhs, only 62 lakhs will go from there. And this 62 lakhs, which is due from 2015, will have a calculating interest at 18%, if not 21, every with quarterly, with monthly rates.
Claim will keep on inflating.
that's it.
Doing something good for the state. If you are making that submission, you are in more deeper trouble. What do you say, finance? Or you don't know anything?
This matter. Here, it depended on the
So we say that the finance will pay whatever that is.
that is. That it,
Because they are one of the submissions out there is that we have tried our best to make certain payment, but because of the finance paying, isn't it? That's a part of the speaking order. Although the government should say in a one voice, but with so many departments, the government is speaking differently.
And Lordship, some people they pay, no questions asked. They pay huge amounts, interest amounting to 19 crores. But when it comes to me, they are now talking about 18. This also,
So, Mr. Bhattacharya, I give you the liberty only to choose two of these opportunities. Either pay on a mutual discussion or suffer a judgment may have disastrous consequences. Because the amount was in 2019, as per your standard, it was 455 was the and this has now doubled, more than doubled.
More than
Because with 21% with monthly rates, it must have gone twice. So it is now around 12, 13 crore. So if you can settle out and come to a finding, it's good. But
I would like to take,
No, take instruction only in respect to how much, whether you are going to study. But this matter has to finish this before we. Madam also has to be happy before.
Lordship, when do we have it? A date maybe? When?
Next week.
may I pray for a date after vacation?
No.
Please, no. This is going on
It
too
is the
far.
date to obtain instructions whether you like to settle or not. Nothing more than that.
Fine. Then before that,
We'll have it next Friday.
next Friday.
Not this Friday, next Friday.
That's
In the
19th of
meantime,
September. Not Lordship,
let
Lordship.
the petitioner person go and have a talk with his people on Monday with the commissioner and secretary PSC. And you finalize what is.
Lordship, can we have it
And
on
on
the 18th?
Friday, I'm going to take it up.
Can we have it on the 18th, Lordship? It's not inconvenient.
Thursday.
Yes.
Okay. Thursday, Monday, you have a word. Try to settle it out. If they are well and fine, ask them to finish it up by May 2020. Yeah, after COVID, there should not be any interest. Try to implore upon them. And madam, you also explore upon your client to.
Lordship, my clients are very willing. We are also willing to close down at 19, leaving 5 years.
See, I'm not recording the submission. But
Right.
if not, you are going to suffer a judgment which will have a
Given,
lot of implication upon.
give and take, we're
With a
willing to do.
21 crore on this amount, other two petitions are there. So let them have a meeting at 2 o'clock with your additional chief secretary or who?
Special chief secretary. Special chief secretary.
Special chief secretary. Have a meeting on Monday and Tuesday, whatever be there. But Monday I fix the date on which a meeting can be held. And then we take it up on Thursday. Thursday, 18, madam, there will be a problem. I'm having a division bench at 3 o'clock.
17, Lordship, in that even? 17?
17th is too early. Negotiation time take. Okay, 18th, we'll see.
Let it be on the 19th then. Let it be on 19th then.
19th at the top of the list.
19th.
19th at the top of. The matter having been heard at length and taking into account the implication if the argument made by the learned counsel appearing on behalf of the PHE department is to be accepted. This court have duly heard the learned counsels appearing on behalf of the parties. From the materials on record, it transpired that the impugned speaking order by which the petitioner's entitlement towards the interest in terms with section 16 of the Micro, Small, Medium Enterprise Development Act 2006 have been denied appears to be prima facie not tenable. The reason being, the reasons being that the memorandum of understanding dated 14/5/2019 would have no application in respect to the payment due by the PHE department, in as much as the memorandum of understanding dated 14/5/2019 relates only to the central government share. The speaking order further bases its decision on the question that it could not be ascertained as to whether the petitioner would be a small enterprise. But the materials on record clearly show that the said decision was arrived at without taking into consideration the Entrepreneur Memorandum Part 2, which was issued to the petitioner on 1st of March 2014. And the same have also, and the respondent PHE department further have not taken into consideration the MSME Act 2006, read with the notification dated 29/9/2006, issued by the additional secretary Ministry of Micro, Small and Medium Enterprise, Government of India. It further appears that the respondents PHE have also not taken into consideration the circular dated 1/8/2007 was the two notifications. The notification dated 29/9/2006 and the circular dated 1/8/2007 have been brought on record by filing an additional affidavit by the petitioner. This court further takes note of that as on 30th of November 2020, the state have already, the PHE department have already admitted that there was an amount of rupees 62 lakhs 33,618 payable by the respondent PHE D. And further, the interest as on that day was rupees 4 crores 55 lakhs 79,715. It further appears from a reading of section 16, read with section 16, 17 of the MSME Act 2006. That statutorily, the entitlement of the interest have been prescribed. And further, this entitlement is statutorily also recognized by Section 17 of the said Act. This court, while hearing the learned counsel appearing on behalf of the party, and taking into account that the interest amount would far, and taking into account the colossal amount, and taking into account the implication of the huge interest amount, had inquired with the counsels appearing on behalf of both the parties as to whether some sort of settlement can be arrived at so that the settlement interest portion could be reduced. Mrs. Emma Hazurika, the learned counsel, senior counsel, submitted that her clients are not adverse to having a negotiation. Mr. Ibotakur further submitted that he would also advise his client in that regard. As the matter has been heard at length, as the matters have been heard at length, this court fixes the instant proceedings on 19th of September 2025 at the top of the list for further hearing. In the meantime, the petitioner and the respondent would be at liberty to negotiate, to come to a negotiation, would be come to a would be at liberty to negotiate. Would take would be at liberty to take steps for an amicable settlement. This court inquired with Mr. Ibotakur as to when the petitioner, the representatives of the petitioner could meet the special secretary, PHE, in that regard. He, upon instruction, submits that on Monday at 2 p.m., the representatives of the petitioner can approach the special secretary to have a discussion.
Lordship, the minutes will be recorded because last time they called us, they did not record any minutes.
If it is not done, they know.
Lordship,
That is why I have mentioned there was no necessity of me mentioning they're making a prelude. The only reason is they know why. And what is there is also they can see the video.
Lordship, item number 7 and 8, only the amounts are different. I'll give it to the. I'll give.
The reason simple, and if the date also, the speaking order date.
Yes. Speaking of the date, I think it's same for all. Right?
There'll be one order only. This
Same,
order is
same.
okay, but the reason is the same.
The reason is the same. So
The
I'll just
dates
give
will
this
be,
amount.
But in all the cases, the EM has been different dates.
Amounts are different.
EM part
Even the part two different.
and amount. This kind of, huh? You give it.
I can give a note
Yes,
tomorrow.
yes, please. At 2 p.m. that day. Huh? I don't have a serial.
Item 3 fixed at 2 p.m.
I got the judgment, your lordship. Last question suggested regarding that. Madhika. Desilting work was done, was allowed, my lord. So your lordship will kindly see page 19. It's fully covered by the judge. There is no sale. So there no transfer of any items. So therefore they. I'll just place the facts on.
Where is that improved communication? 8/8/2018.
Page 36.
8.
36.
Where is your contract?
Contract is at, my lord, pay, is a work order, page 21.
Huh?
First, your lordship will kindly see page 19.
Yeah.
This is the NIT for desilting work. They have to use their tractors, desilt it and shift it somewhere else. From the owners of the tractors. Page 21 is the contract.
Who is paying for the state government? No, the finance and taxation. Why on earth haven't you filed an affidavit? You don't need the money.
Well, the reason why I have not filed this, well, the infraction is, it speak otherwise. Says that, well, from the contract, well, whatever is there, it's not discernible that whether there was any such sale to, well, impose VAT. Lordship will see my part.
You see, Mr. Das, the problem is this is not a case which will apply. Taking into account, this is not a case for hire or leave.
KP
Okay.
Muzika bata.
This is a case as regards execution of works contract.
Yes.
And when it is an execution of works contract, therefore the question is you are to follow, because when a work contract may have a different parts,
Components.
components. So therefore, by amendment being made, is when there is an execution of a works contract, there is an element of sale. By in view of the definition of sale amended by Article 366(29)(a) of the Constitution.
Judgment की देखो ना KP Muzika. Oh.
But the fact remains, whether it is there or not, you are bound as per a statute.
We are bound, my lord, but to ascertain that, my lord, if anything, any contract or anything that can be placed, my lord, we can examine that.
No, there is no contract. Yes, who is paying for the state? Otherwise, this is done by the agriculture division. Agriculture, engineer, agriculture. Yes. Tender has been issued by executive engineer, agriculture department.
Yes. We were just executing, giving the certificate.
Who are you? So, no, you issued the tender. I see page 19, you have not looked into the file. That's state of affairs.
Yeah, also on the basis of the direction of the deputy commissioner, the tender was issued because the revenue and disaster management, they sanctioned the amount. Lordship.
Everything understood. This is a case by which a contract has been, you are issuing a works contract.
Yes.
So if it is whether you mention it or not, when there is a sale, by operation of law, the bill has take place. Whether they have to pay or not, that is a different thing. If you don't deduct that 5%, isn't it the deduction mandatory in terms with the VAT Act? Of? Yes. And that is already there, but the deduction of tax at source. This is deduction of tax at source is being made to a particular extent. This is, you are to do it, you are under bound to do it. Like a debt collector. You are a finance and taxation lawyer. How do you not know and you are not making a submission?
Lordship, it was executed before, Lordship, by
What?
the agriculture district authority.
So the moment is
No, no.
agricultural, that Mr. B. Chaudhary completely
no,
keeps
no.
his mind blocked, although he's also a finance and taxation counsel. And is it something like that? That you will operate in silos? That look here, when I am appearing for agricultural department, I don't know anything about finance or taxation.
No, that's
That
not.
tell me,
Lordship,
then we can have it in that manner only. Which is the clause for the purpose of deduction of tax at source?
Section 43 of section 42. That is the sale, my lord, with all these kind of.
You have 47. Every person other than an individual. A Hindu is so and so. So and so, farm company not under the control of the government, responsible for making any payment or discharging any liability on account of any amount purporting to be the full or part payment of a sale price or consideration for transfer of property in goods, whether of as goods or in any form involved in execution of works contract, shall at the time of credit to the account of payment of the so and so of such amount in cash so and so or in so and so whatever, deduct in the prescribed manner an amount calculated at the rate of 12.5 paisa in the rupee of the taxable turnover of such works contract. That's state of affairs of the finance and taxation councils. It is for this court to show. So you are bound. It is by the statute you are bound. When application has been made by the contractor in that behalf, when you are not bound. When the application has been filed, then look here, I am under a composition scheme, so I may be excused. Then you don't do it. This is the composition scheme. Is satisfied that any works under reference is separable and involves both transfer of property and goods and labor and services, or involves only labor and accordingly justified deduction of tax only on the part of the sum in respect of the work or as the part of no so and so shall be heard and so on. Where such certificate is produced by the contractor before the person for payment, such payment shall, unless the certificate is cancelled in any person mentioned in such a may in any contract or involved in the execution shall furnish within 15 days for payment. And every person other than an influence for money. I think you catch hold of that agricultural officer who has not done him. Ask him to pay for his salary. Who is required to deduct tax under section 47 well within 10 days from the expiry of the month deposited in the designated branch. Problem arises when the finance taxation council is also appearing for agriculture. Grant of certification of year. Now, have you been registered for under the composition scheme?
No. They are just contractors. They are just contractor. They have this.
Mr. This is cannot.
Not registered.
If you are under the composition scheme,
No,
what
no.
happens? Then you cannot go into anything else. So directly on that amount, otherwise you are normally to pay 12%. But if you are in the composition scheme, then it is a 4%. Then you don't go.
But they have
is
given
like
the-
nowadays like the income tax, earlier income tax and presently. Earlier income tax, you used to get a lot of statutory deductions. Now those statutory deductions are removed as per the new pension, new income tax scheme, that these you are to pay. Something like that.
Notice is under VAT.
That is proper. Should have been given. In fact, they should have deducted, not paid you that amount. Isn't it, Mr. Gupi Gogoi?
These persons are individual
These have
persons.
been released. Question is, if they can recover, recover. If they don't, then the question there was a stay.
Stay was there.
And then stay is there in 2018. Stay being there till the next fixed day. Shall continue. Interim order has been continued. So therefore, this period you cannot do it. We have to exclude this period. Now to if they are still doing business out there, you can do whatever you feel like. But this order, nothing to challenge this order. Okay. Or you have to tell this period has to be excluded because you may have to, the finance and taxation has to take steps for issuance of notice of contempt payment. Because this is the amount which they have to pay as per the tax.
Well, if I can look at it, submit some. That case, we can-
Assessment also,
interest will come.
interest penalty will come.
They are all individual tractor owners. I don't
Tractor,
think
a
they-
person having a tractor is a very rich man. And he is doing work for desiltization.
About 11%.
How much is the amount that which you has been given to you?
Totally is about 14 lakh something.
8,100 per hectare.
Correct.
And one person has been given how many hectares? 310 hectares. How much?
Yeah,
That 310 hectares of 8,100. How much is it? The other person, again another person, 148 hectares. Then 150 hectares. The amount of so and so was sanctioned against this. You've got the money.
Yes. Amount has been paid. This is only on the basis of the AG note.
Rightly so. AG is doing this. So you are only challenging 10. Hello? You dismiss your petition. Heard Mr. B.D. Das, the learned senior counsel, assisted by so and so, hearing on behalf of the petitioner. Mr. Mr. S. Dutta appears on behalf of the respondent number 1 and 5. Mr. B. Chaudhary appears for respondent number 2, 3, and 8. Mr. K. Gogoi appears on behalf of the respondent numbers 6 and 7. The Architaluka appears for the respondent number 4. And 5 somebody is appearing, na? Disaster Management Authority? Right. And Mr. B. Gogoi appears for respondent number 9 and 10. The petitioners herein who were awarded contracts pursuant to a short notice inviting quotation dated 10 dated 10/11/2015 have questioned the communication dated 8/8/2018 issued by the additional Deputy Commissioner Dhubri to the Executive Engineer Agriculture, whereby directions were issued that steps be taken to realize the VAT amount at a rate of 5% from the contractor's bill and deposit the same to the treasury challan under the proper head of accounts and submit a report. The question arises in the present series as to whether the issuance of the communication dated 8/8/2018 by the Additional Deputy Commissioner Dhubri calls for any interference. The materials on record clearly show that a short notice inviting quotation was issued by the Executive Engineer Agriculture from owners of tractors registered under the Central Motor Vehicle Act 1988 for desiltation work by tractorization in the agricultural land affected by a situation in various locations as mentioned in the short notice inviting quotation. The records further reveal that the petitioners herein were issued various work orders. The price has been fixed in terms with the work order at rupees 8,100 per hectare of agricultural land. The work order, petitioners have not placed any document to show that the said amount was inclusive of, have not shown that the said amount of rupees 8,100 per hectare was inclusive of taxes or exclusive of taxes. Be it as it may, the petitioners have questioned the communication dated 8/8/2021, 18, on the ground that the question of deduction of an amount of 5% by way of VAT could not have been directed by the Additional Deputy Commissioner Dhubri. This board takes note of that the work involved in the instant proceedings, the contract work in question would come within the ambit of, within the meaning of sale, a constitution condition. This court duly takes note of that from a perusal of the short notice inviting tender quotation as well as the work orders so issued, the work in question is a works contract. Taking into account the definition of sale in the Constitution of India, in Article 366, bracket 29, capital A of the Constitution of India, as well as Section 243, bracket 43, Roman 2. It is the opinion of this court that the work performed, that the work carried out by the petitioner would come within the ambit of works contract and would be a sale within the meaning of Article 366, bracket 29A of the Constitution of India, 29A, Ako bracketed B, small b, as well as section 243, Roman 2 of the Assam Value Added Tax Act 2003. Taking into account that it is a sale, the respondents in the agriculture department, or the authority making the payment were statutorily obligated to deduct tax in terms with section 47 of the Assam Value Added Tax Act 2003, read with Rule 28 of the Assam Value Added Tax Rules 2005, Nikki? 2005. Under such circumstances, this court do not find any error in the communication dated 8/8/2018, consequently requiring interference from this court. Accordingly, the instant petition stands dismissed. Interim orders passed earlier. stands
K.
vacant.
Mujika, I relied on your lordship, I just mentioned it.
Which one?
KM Mujika.
Mozika would not come. Mozika will be on respect to another thing. Mozika is on respect to hire. This is not a case of hire. You were not asked for that they were taking the vehicle.
No, why 31, the section, paragraph 31, 5 conditions required for the purpose
No,
of considering sale.
You see, that is a case coming under 366 bracket 29C,
Yes,
as well
29.
as 243 Roman 3,
29D.
29D.
D.
So there what has happened is when you give the vehicle on hire, whether it is a hire or it is a sale, where
was
you
discussed,
keep
yeah.
it, this is not the case of that. Here you were asked to go for desiltization.
Yes.
This is a work. So when you give this particular document, you are saved by only, they are asking only 5%.
12% is written, 47.
Actually 12% each.
47 it is there.
But they have done only 5%. It is only when it is a composition scheme, it is 4%. But you are not in a composition.
But as I said, doesn't come under sale
Huh?
because of this act. I understand what your lordship said. Your lordship may reject it.
Anyway,
Mojika case, I relied on Mojika, your lordship may reject that.
Huh?
I relied on Mojika, your lordship may reject that. Something I have done.
Oh yes, no, but I'm not putting that Mozika thing because it's not so proper on your part to show Mozika in respect to a
Work
work
contract.
That is why I'm not putting it. Because when a judgment later on it reported it to in a very bad light about the lawyer.
On last occasion, Lordship had ordered it 2025.
Mm.
Lordship directed us to file an affidavit regarding the pen taken by the petitioner subsequently.
Only on that limited aspect
Lordship,
pertaining to submitted that the submission to make would be apparent from reading the communication and the Yes, what you say in your affidavit?
Lordship, government has
Additional
issued
affidavit,
a additional affidavit, Lordship, filed on 1/9/2025. Come to the case 124. 123 Lordship.
111.
Oh.
So you mean to say in your long affidavit,
Provided
that
by
the
the,
amount which was paid by a 20% high, 20% high was an ad hoc
Piece 123, Lordship.
pay,
Piece 123.
yet
Second paragraph.
above the component will not affect here. Is that inside other
This order has been passed in reference to the 26/11/2008. That was annexed in the next list. Piece 125, Lordship. Para 4. Clause 4.
page 124.
No, here
You are not able to accept. The price cases of their given in people pay last year. Don't be decided as on last year.
And regarding the financial implication, Lordship, clause 16.
Huh?
Clause 16. In terms of this office memorandum, the 2013 letter order was passed.
Huh?
In terms of this office memorandum, Lordship, the 2013 notice has been issued, whereby it was excluded PF and other arrangements. So ad hoc pay enhancement granted here was a fixed component.
Document been challenged here,
No, Lordship.
2013.
No, Lordship. Here petitioner's entire case on the basis of a settlement which has been they have himself stated that that was not implemented till date. Paragraph 4 of the petition. But entire paragraph if released, Lordship, on the basis of the death settlement. Lordship knows that the settlement, implementation of settlement, the article 226, Lordship.
Yes, Mr. How do you take care of that situation? 2013 is that of
No, basically, basic and DA was announced. Case is very.
it was given on an ad hoc basis.
No, that
Ad hoc basis, then it was clarified that it shall not affect the PF.
yes, let me assume that is. But
You have
with
enclosed that
by
document.
an administrative order, they have taken away my statutory right. That right has been conferred under this act.
The right has been conferred under this act, but this was only as an ad hoc. There is an increase being made on an ad hoc basis.
No.
Without
In-
finalizing this.
No, basic and DA has been announced. Enhanced. Now, even if you should come, if I go by through his argument, you'll come to page 124. They have passed this order.
Yes.
Clause 4. CPSE, which are not able to adopt revised pay scales 2007, may give an increase on the basic plus DA drawn on pre-revised scale on 1/1/2007 with an uniform lower treatment of 10% or 20% depending upon their affordability with the approval of the Ministry of Department. So naturally basic has been announced. If the basic and
These will be given in the policy decision. this policy decision says that these 10 or 20% upliftment which will be given subject to the ministry's approval. The ministry has given an approval, okay, you give a 10 to 20% hike as the fitment is being given, but this fitment is only a temporary phase till and they shall not affect the PF factor. Now, this is a document which has not been challenged. How do we take care of that?
No, look, that is true. This is not a document has not been challenged.
You have raised this during the course of the argument out here. Although that was never your reading. But when you made the submission, therefore I allowed that submission, but allowed them also.
No, look,
Now they are taking up that issue to the defense.
And this document is annexed of a page.
No, I've seen it.
Yes.
He has
No.
closed it. He has not challenged that.
No.
So that would not include the PF. So you has not challenged it. How do you touch on that?
no, your lordship allowed me to. Your lordship allowed me to incorporate this reading, blood. Now your lordship come to second notification. That is. That is a statutory right, blood. The consequence of non-payment of provident fund has been laid down in the statute itself, blood. I will come to that later on, blood. Page 64, next order, blood. Here they have granted PF.
Dated?
Huh?
Dated?
Dated 30th May 2016.
This is of 2016.
With effect from 1/6/2000.
I am directed to refer to your letter dated on the subject cited above and convey the approval of the Honorable Minister Chemical and so and so for grant of DF works any allowance of PF on 20% of the basic pay as of so and so with effect from so and so to all regular employees in lieu of the fixed amount of equal to 20% of the basic pay and year on the existing scale, that is so and so and so and so, as per the provisions of the financial implication of the account of the certificate has to be borne by the company. So this has been given in 2016.
16.
Your basic case is that give me this from 2010.
Yes.
That is your prayer in your petition.
That,
This is
that
the
was my
document.
point. So it 2010, then automatically PF will come. Because these allowance,
That is
this letter grants the PF.
But Mr. Dasgupta, that is your plea. You have asked that this document should be given effect from 1/1/2010, 2010 or whatever, from 2010. But the problem arises is that at that point of time, if you have not got the benefit, you could not get the benefit out there. You retired in the meantime. That's it.
So now, super, my right to have the provident fund. That is a statutory right, my lord.
You are getting the provident fund, they are already paying. They are not paying on the additional 20%.
Yes, yes.
Of the increase, they are not paying.
That is
That was never your case at all. But you should have challenged the document of 2013. You have not challenged every day. I allowed that plea to be taken up, but they have come up with that justification to the defense. This is a matter of 2016, nah?
Yes.
That,
So this is an administrative order, my lord, by experience of yes, technically probably.
You see, the problem which arises with this court is administrative order, everything is realized out there, but it will have a financial implication now in respect to settle claims. You have not challenged that then. You should have challenged it. In 2013, you knew about this. How on earth you could have only given me 20% hike without the PF? You never did that. Matter went on in 2016 also, you never did it. As on today, after 12 years also, we don't have that. So how do I allow you? Matter has to come to a rest. Certain things, if it is wrong, it has to be challenged there. problem arises with that document.
Actually, since 2007, no revision of pay. Miller.
Sad, but can't help it.
Only,
Just for
only,
example,
only
let me-
10% base.
Let me tell you one thing. There are many CPUs at that point of time. And that day I went to 60th while going to Kohima. Went to 60th. That company is also not doing well. That's also not big. They also come within. They are not a position to do it. They are trying to outsource manpower. These are things which are going on. They are not in view of the private industries coming in. A lot of good cement plants which are private, they are with that competition, the CCL is not able to match. And for that, employees are suffering. The thing is that you need a more impetus that has not been done. It is absolutely within the discretion of the government to do how it is.
No, this
So,
order is
court
apparently,
role is very limited because you have accepted the 2013 year.
no, this is an error apparent on the face of the record itself, though I have not challenged it. Because by issuing an administrative order, you cannot charge.
I cannot allow you to this. Error apparent on the face of the record does not appear out here because of the fact that this was a document you should have challenged that and say that how on earth you are only giving me this, everything got settled, all these people retired. Now, most of them retired prior to 2015.
All retired pattern.
So all these people, some of them remain, but most of the people have retired.
All these
Because
people
as
are
I could
retired.
see from that day, after that day you said, na, somebody had retired after that. Also.
Yes, okay.
You see,
Days 29 to 31. Retirement days are. Some of the are the 2016 also deal also. After that,
those who have, they are like 119, petition number 119, he retired in June 2016. Then
serial number 24
154.
serial number 24 10 2015
So they retired prior to the, somebody got the year, 24 got
after the effective date also.
the, 20, he 10 2015, he retired.
10 2000.
So my initial case was
All these people retired prior to that May 2015 and 16.
Yes.
All these people retired May, one retired after that, 106. 106 retired frequently, 119. 106 and 119.
The process peruse the paragraph 11 and 12 of the petition. The petitioner is trying to impress that these are the part payment of the settlement regarding the 2016 notice.
settlement was made. but it could not be implemented because of this financial condition. And there is a clause that it will be implemented with the approval of the government. And government passed these two orders. That is in continuation of the settlement. But though it could not be fulfilled by full extent. That was my pleading, if I'm not.
There is one judgment also recently, a Supreme Court judgment in respect to those who have retired prior to their policy decision that cannot be brought in. They do not come within the same. The question of a reasonable classification aspect was brought in, that there was no reasonable classification. The Supreme Court says that those who have retired earlier could not be brought in. Do you have that?
That might be in for other context, not in the
this is
context
for
of.
the purpose of these benefits out there. But for pension, it is again on a different line. Following the DS Nakara judgment.
The DS Nakara has been diluted to some extent.
But for this, it is another. I hope heard Mr. A. Dasgupta, the learned senior counsel, assisted by the
Vida.
appears on behalf of Mr. K. Kohli appears on behalf of the respondent number one. And Mr. Kumar Sharma appears on the petitioner therein, who are in total 145, are retired employees of the respondent number one. It is the case of the petitioner that the employees of the respondent number one, that it is the case of the petitioner that a settlement took place between the employees of the respondent number one and the management in the year 2003. Relating to the wage payable. The said settlement expired on 31/12/2006. After the said settlement, after the expiry of the settlement, another settlement was arrived at on 29/2011 with effect from 1/1/2007. However, this settlement was not implemented. On 5/4/2013, the Ministry of Chemical and Fertilizer issued an order issued a communication to the chairman come managing director of the respondent number one in relation to pay revision of the respondent employees of the respondent number one. In terms with the said letter, it was informed . that the competent authority had conveyed the approval for increase in the pay of regular employees by a fixed amount equal to 20% of the basic NDA of the individual on existing scale as on 1/1/2007, payable with effect from 1/1/2010, as per the provisions of clause 4 of the office memorandum dated 26/11/2008. In the said communication dated 5/4/2013, it was categorically mentioned that the fixed amount would not attract PF and any other allowances and should be strictly in accordance with the OM dated 26/11/2008, wherein besides other instructions, it was specifically laid down that the additional financial implication on account of the above increase has to be borne by the central CPSE with central
Public sector unit.
public sector
Unit.
unit
Unit. Public sector unit.
unit.
Unit. UNIT.
No.
Undertaking.
No. Unit
Undertaking.
enterprise.
Oh, sorry.
CPSC. CPSC.
PSC.
Oh, enterprise.
Central Public
PSU.
Sector under
PSC.
bracket CPSC, concerned from their own resources, and no budgetary support to be provided by the government. Subsequent thereto, on 30/5/2016, the Ministry of Chemical and Fertilizers, Department of Fertilizers, Government of India, had intimated the chairman and managing director of the respondent number 1 that thereby conveying the approval of the Honorable Minister, bracket chemical and fertilizers, bracket close, for grant of PA, perks, any allowance and PF on 20% of the basic pay as on 1/1/2007 with effect from 1/6/2015 to all regular employees in lieu of fixed pay amount of equal to 20% of the basic pay NDA on the existing scale with effect from 1/1/2010, granted earlier by the communication dated 5/4/2013, as per the provisions of clause 4 of the office memorandum dated 26/11/2008. It was further mentioned that the financial implication of the account of above increase has to be borne by the company from their own resources and no budgetary support would be payable by the government. The petitioners thereupon submitted a representation to the respondent, to the chairman cum managing director of the respondent number 1 on 28/7/2016, claiming that they are entitled to the benefit on the basis of the memorandum of settlement dated 29/2011. It is the specific case of the petitioner that the petitioners have received part payment by orders dated 5/4/2013 and 30/5/2016. And further, as the part payment and further, as the petitioner have been deprived of their due payment, appropriate redirection and order is required to be issued. It is the further case of the petitioner, as will be seen from paragraph number 12, the writ petition, that both the sets of employees of the petitioner are employed who have retired from 2010 to 2015 and who are in service as on 1/6/2016 are entitled to have money due in terms with the settlement dated 29/2011. However, by the order dated 30/5/2016, this payment against the however, the order dated 30/5/2016 indicated that the part payment against the settlement would only be made to the existing employees. And it is on the basis thereof, the petitioner have assailed the impugn order, applicability of the impugn order dated 30/5/2016 as violative of Article 14 of the Constitution. The relief, therefore, which was sought for by the petitioners in the present writ petition is that the impugn order dated 30/5/2016 should be made applicable with effect from 1/1/2010 and not from 1/5/2016. To the writ petition, pursuant to the writ petition being filed, an affidavit in opposition was filed by the respondent number 1, wherein it was categorically mentioned that the respondent number 1 is engaged in production of fertilizers and has its production plant along with residential colony for its employees at Namrup. It was mentioned that the Hindustan Fertilizer Corporation Limited, a government company, had 4 establishments, including the Namrup establishment. The company was declared a sick company as per the order of the BIFR, and the entire company was directed to be closed. However, at the prayer of the central government to continue with the Namrup plant, BIFR ordered that it can be restructured by the central government by developing the unit and only after forming a separate company for the same. Accordingly, a new government company, that is the respondent number 1, was established with effect from 5/4/2002. It was further mentioned that the Department of Fertilizers Ministry of Chemicals and Fertilizers, Government of India had authorized the management of the respondent number 1 to negotiate the wage revision based on the 1997 scale of pay. Accordingly, pursuant to the charter of demands submitted by the unions and the decision of the government conveyed by the communication dated 25/8/2003, the negotiations were held with the unions in various meetings. Finally, a memorandum of understanding was arrived at on 22/9/2003 in respect to the wages, allowances, and fringe benefits under the 1997 scale. It was mentioned that the next. It was further mentioned that the memorandum of settlement dated 22/9/2003 was made effective from 1/8/2003, and the same remained in force till 31/12/2006. In the meantime, the central government had set up a pay revision committee to recommend revision of pay and allowance for the board level and below board level executive and non-unionist supervisors on central public enterprise with effect from 1/1/2007. Following IDA pattern of pay scales as the last revision of the scale of pay of the above categories of employees were made effective from 1/1/97 for a period of 10 years, and the next pay revision fall due from 1/1/2007. The government, after considering the recommendations of the second pay revision committee, had issued an office memorandum dated 26/11/2008, whereby the government had decided to grant an interim relief as an advance to all regular employees as on 1/1/2007. Clause 4 of the office memorandum dated 26/11/2008 specifically provided that, inverted comma, the CPSCs which are not able to adopt the revised pay scale, bracket 2007, bracket close, may give an increase on the basic pay plus DA drawn in the pre-revised scale as on 1/1/2007, with a uniform lower fitment of 10% or 20%, depending upon their affordability, with the approval of the Ministry of the Department, inverted comma close. It was also mentioned in the said office memorandum, more particularly in clause number 16, that the additional financial implications on account pay revision has to be borne by the CPSC concerned from their own resources, and no budgetary support would be provided to the government. It was further stated, next. It was further stated that after various negotiations, a new memorandum of settlement was arrived at on 29/2011. The said clauses of the agreement were specific that to fulfill the agreement, no budgetary support will be provided by the government, and increased obligation must be internally generated. Further to that, it was mentioned that though the memorandum of settlement dated 29/2011 was executed on revision of wages structure with effect from 1/1/2007, but due to consistent loss incurred by the respondent number 1, the pay revision which was supposed to have been revised with effect from 1/1/2007 could not be implemented till date, which has been admitted by the petitioners in paragraph number 4 of the writ petition. It was further mentioned that the Government of India, Department of Fertilizer, by the letter dated 28/6/2012, granted an interim relief as an advance to each employee of the respondent number one. As an advance to each employee of the respondent number one at the rate of 20% of bracket basic pay plus DA bracket close on 1/1/2007 per month starting from June 2012. And the same would be adjusted with the final settlement of the wage revision under the 2007 pay scale. Subsequent thereto, on 5/4/2013, the government of India, by its order, granted an enhancement in the pay of regular pay employees by fixed amount equal to 20% of the basic plus DA of the individual on the existing scale of pay as on 1/1/2007, payable with effect from 1/1/2010, as per the provisions of clause 4 of the office memorandum dated 26/11/2008. Mr. Koilda, why there are two aspects? In 2012 one and 2013 one?
Subsequently, in paragraph we have stated, paragraph 11, that as the respondent company could not be able to implement the memo of settlement due to constant loss incurred by the company, therefore the company had again approached the government for grant of interim relief with some.
Now, this already has been granted on but paragraph 10.
Yes, but subsequently again approached.
But it is the same thing. It's a reiteration of the one in 2012.
Yes,
But the 2012 did not exclude PF.
Yeah.
Isn't it?
16.
So by 2013, you made it excluding the PF.
Yes.
Yes. That is issued by the government.
Maybe, but you excluded the PF in 2013.
Yes, it's.
It appears therefore, because otherwise there was no necessity of issuing the 2013. Oh, no. There's a reason why. It is from the month of June 2012 it was. So here you gave another from 1/1/2010.
2010. Okay, from 1/1/2007 from the month of June 2010. In this,
No. But earlier one was from June 2012. Now you gave further retrospective operation from 1/1/2010. Yeah, the government of India, Department of Fertilizer by its letter dated 28/6/2012 granted an interim relief as an advance to each employee of the respondent number one at the rate of 20% of the basic pay plus DA as on 1/1/2007 per month, starting from June 2012. And the same shall be adjusted with the final settlement of wage revision under 2007 pay scale. It is further relevant to observe that the respondent company, respondent number one company, again approached the respondent number two. And the respondent number two thereupon issued another communication order dated 5/4/2013, thereby granting the enhancement in the pay of the regular employees by the fixed amount equal to 20% of the basic NDA of the individual on the existing scale as on 1/1/2007, payable with effect from 1/1/2010. as per the provisions of clause 4 of the office memorandum dated 26/11/2008. Subsequent thereto, the government of India, by another order dated 26/35/2016, granted EA, perks and allowance and PF on 20% of the basic pay as on 1/1/2007, with effect from 1/6/2015 to all employees of the respondent number 1 in lieu of the fixed amount of equal to 20% of the basic pay, and DA on the existing scale with effect from 1/1/2010. As per the provisions of clause 4 of the office memorandum dated 26/11/2008. It was further mentioned that the central government in the Ministry of Chemical and Fertilizer had taken a conscious decision that the benefit of the letter dated 35/2016 would be granted with effect from 1/6/2015 only. And the respondent number 1 was bound by the resolution adopted by the government of India in the Ministry of Chemical, Fertilizer and cannot go against the directive given in the communication dated 35/2016. It was further mentioned that our meeting was also held between the respondent number 1 and its union on 11/6/2016 regarding the implementation of the order dated 35/2016, which has already been annexed with the petition. Therefore, from the stand which have been taken by the respondent number 1 in its affidavit, it is apparent that the respondent number 1 had acted on the basis of the instructions so issued by the respondent number 2. The justification as to why the communication dated 35/2016 why the benefit of the communication dated 35/2016 was limited with effect from 1/6/2015. And not from 1/1/2010. Can be seen from the justification so given by the respondent number 2 in the affidavit in opposition. The respondent number 2 had filed the said affidavit in opposition on 35/2018. It was categorically mentioned that the Union Cabinet in its meeting held on 21/5/2015 at entirely approved recognition for financial restructuring of the respondent number one. Accordingly, the cabinet approved implementation of the 2007 pay scale in the respondent number one as per the TPE guidelines. It was also mentioned that the respondent number one could not comply with clause 3 of the TPE guidelines, but it was able to comply to the clause 4 of the DPE guideline. Therefore, in accordance with the cabinet approval dated 21/5/2015, the cutoff date was fixed on 1/6/2015 for implementation of the salary hike. And as such, the allegations so made in the writ petition is not correct, for which the writ petition was liable to be dismissed. The instant writ petition was filed, came up for hearing before this court on 12/8/2025, when the counsel appearing on behalf, senior counsel appearing on behalf of the petitioner, submitted that he would limit his submission to the effect that the allowances insofar as the PF contribution is concerned should be given with effect from 1/1/2010, inasmuch as by the communication dated 5/4/2013, the respondent number two have increased the pay of regular employees by a fixed amount equal to 20% of the basic NDA on the existing scale as on 1/1/2007, which was made with effect from 1/1/2010. On the basis of the said submission, this court granted the liberty to the respondent number one to file an affidavit inasmuch as the said aspect was not a part of the pleadings. In pursuance thereto, an additional affidavit in opposition was filed by the respondent number one, wherein, amongst other, it was categorically mentioned that the communication dated 5/4/2013 was issued in pursuance to the office memorandum dated 26/11/2008, and more particularly clause 4 of the said office memorandum. It was further mentioned that in the communication dated 5/4/2013, it was stated that there shall be only an increase in the pay of the regular employee by a fixed amount equal to 20% of the basic NDA of the individual on the existing scale as on 1/1/2007, payable with effect from 1/1/2010. It was further mentioned that the above fixed component, that the said fixed component, it was further mentioned that in the communication dated 5/4/2013, it was categorically stated that the said fixed component would not attract PF and any other allowances which are strictly in accordance with the office memorandum dated 26/11/2008. It is further seen that that the petitioner have also filed an additional affidavit bringing on record the pleadings, bringing on record the said stand which was not the said stand, so bringing on record the contention so made by the learned senior counsel before this court on 12/8/2025, Was- In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties. Was- The issue involved in the instant proceedings is from the basis on the from the perusal of the materials on record. It is seen that the issue involved in the instant proceeding initially and prior to 12/8/2025 was as to whether the respondent authorities were justified in limiting the benefits conveyed by the communication dated 30/5/2016 with effect from 1/6/2015 and not from 1/1/2010. The answer to the same can be seen from the perusal of can be seen from the answer to the same. The materials on record categorically show that the respondent number 1 was initially a part of the Hindustan Fertilizer Corporation Limited, and it was established on 5/4/2002 as a government company after the BFI full form is the Board of Infrastructure and Financial Reconstruction, permitted separation of the respondent company, permitted the separation of the Namrup unit and formation of the new company in the form of the respondent number 1. The fact that the respondent number 1 is running into losses is not in dispute. It is further seen that from the office memorandum dated 26/11/2008 that the Ministry of Heavy Industries and Public Enterprise, Government of India, had taken a decision on the implementation of the revised scale of pay with effect from 1/1/2007 in respect to central public sector enterprise. Clause 3 and Clause 4 of the said office memorandum being relevant are reproduced here in under page 124. 124. Above two clauses show as to when the implementation of the revised pay scale is to be given effect to. It is very pertinent to mention that those central public sector enterprises who are not in a position to adopt the revised pay scale were given a liberty to increase the basic pay plus DA drawn in the pre-revised scale as on 1/1/2007 with a uniform lower fitment of 10% to 20%, depending upon their affordability with the approval of the Ministry of the Department. It is further relevant to take note of that clause 16 of the said office memorandum dated 26/11/2008 further mandated that if there is any additional expenditure to financial implication, the same has to be borne by the central public sector and enterprise. Also, the record further reveals that though there was a settlement entered into by and between the petitioner, the members of the by and between the members of the union of the respondent number one, by and between the employees of the respondent number one and the respondent number as well as the management of the respondent number one. But on account of financial stringency, the said revised scale of pay could not be implemented. The record further reveals that on 28, that upon repeated approach made to the respondent number two, the respondent number two gave the approval for increase in the pay of the regular employee by a fixed amount equal to 20% of the basic and DA of the individual on existing scale on 1/1/2007, payable with effect from 1/1/2010. From the month of June, payable on 28/6/2012. Upon repeated approach, the government of the respondent number two conveyed the approval for implementation of the interim relief of lump sum ad hoc amount as an advance to each employee at a rate of 20% bracket basic pay plus DA as on 1/1/2007 from the month of June 2012. Further to that, by another communication dated 5/4/2013, the increase by a fixed amount equal to 20% of the basic pay and DA of the individual on existing scale as on 1/1/2007 was made payable with effect from 1/1/2010. In the said communication dated 5/4/2013, it was categorically mentioned that the said fixed component shall not attract PF or any other allowances. The records further reveal records and more particularly the affidavit so filed by the respondent number one would show respondent number two would show the reason why the benefits of the communication dated 35/2016 have been limited, have been only permitted to be given effect from 1/6/2015, in as much as it was only on 21/5/2015 the Union Cabinet had taken a decision for financial restructuring of the respondent number one and implementation of the 2007 pay scale in respect to the respondent number one. Taking into account the above, it is therefore the opinion of this court, the question of implementation of the implementation of the implementation of the communication dated 35/2016 with effect from 1/5/16/2015 cannot be interfered with by that making a direction that it shall be implemented with effect from 1/1/2010. Now coming to the question as regards the payment towards the PF, which had been, which was the submission so made by the learned counsel, senior counsel appearing on behalf of the petitioner, with effect from 1/1/2010 by the respondent, number one, comma. It is categorically mentioned in the communication dated 5/4/2013 that that the fixed component so increased up by 20% of basic and DA shall not attract PF or any other allowances. Which, under such circumstances, comma, the question of this court directing the respondent authorities now to pass an order to permit to permit directly the respondent, number one, to deposit the PF for the period from 1/1/2010 in respect to the increase of 20% of the basic and the DA. In the opinion of this court, does not arise. More so, when the decision which was taken on 28/6/2012 and 5/4/2013 were only as were interim measures, and there was no final decision taken for the purpose of granting the scale of pay, revision of scale as per 2007 till 21/5/2016, which was the date on 21/5/2021. 21/5/2015. That is the date on which the Union Cabinet have decided implementation of the 2000 pay scales in favor in the respondent number one enterprise. Accordingly, this court does not find any merit in the instant petition for which the petition stands.
Item 15, state again.
In fact, Mr. Dasgupta made all everything, only one paragraph is that his paragraph. That paragraph where is the cabinet had taken the decision to implement. That's it. All were interim. That paragraph, only one paragraph was. And Mr. Sukumar did not say anything. Yes, Mr. Sahu.
I don't.
Yes, what is it?
My pleasure, Lord. My lord, I have challenged, my lord, the award of the respondent number 5. It was in respect of a pond. And the respondent number 5 was held to be highest bidder. And my ground of challenge are twofold, my lord.
Yes, what is your case?
My lord. The auction notice, my lord, is not for the respondent number 5, my lord.
Huh?
Is not for the respondent number 5. Kindly come at page 41.
But Mr. Sahu,
My
that
lord.
day you took from me a long order in another case and you did not have the courtesy of serving copies to the other side.
Lord, sorry, I'm
Yeah.
extremely sorry, but there was
Because of
staff.
that, we should not be, and this is the conduct of a council.
No, no, sir.
And the conduct of the council being bad there, we also infer, make certain inference in this matter.
I beg apology, but
And
that In that case, my lord, no, copies were served. What, that receipt copy has been, my lord, lost by my colleagues, my
Don't
lord.
say all the things. I've seen the record. Yes, what is your case?
Yes, my lord. At page 42, my lord.
Eh?
Page 42.
Yes, what is it?
This is the guideline, my lord. That, my lord, right hand side.
Gardens and plantation disposal of grass and other natural products. In case of a lease of right of fishing by public or tender, tender, the first preference should be given to fishermen over the society formed by railwaymen. If no such society, the second layer would be given to other fishermen over. No society exists, it may be let out to others by but then not then. So therefore, you say that you are a society,
I'm a society, my lord.
fisherman society
Yes, my lord.
of.
Uh,
Are you formed by railwaymen?
no, no, no.
Then
For-
you
for-
are the second preference.
Yes, second preference.
Okay, how will they know that there is a fisherman cooperative society?
Because I was the existing, my lord. I was earlier awarded, my lord,
Now they are going to give it to others.
to this individual
Where is
person.
the tender?
Yes, that is, my lord, auction notice, in fact,
Tender
at
notice?
page 20.
On the 20. Okay, then. So there is nothing, man. Sir. Your case most probably would be that when there is an existence of already a society,
Right.
where is the question of calling for tender?
No, my lord. Actually, that guideline speaks about two kinds of tender, my lord. One is public auction or tender, and another is open public auction. When there is no fisherman society, only in that case, my lord, that open public auction or tender can be published. So here the open word is not there
Where?
at page 20.
No. If no such society exists, it may be let out to others by open public auction or open tender.
Yes, my lord.
Then,
Because in this present case, my lord, societies are there.
so,
Yes. Then in that case, he will not come into picture because this is not open, but this is, my lord, public auction.
so
When it is public auction
you,
only, I can participate.
you participate?
He participated. But
Have you participated?
yes, I have participated.
Fantastic. Then nothing you mean. Let them take a decision. Then I'm here till vacation.
I have participated. Second ground, my lord.
Dismissed. You participate. Let them take a decision. This is an apprehensive.
No, I have participated, my lord. Kindly see
Then-
at page.
So if you have participated, we'll see whether they give it out to respond number 5 to anybody else.
No,
How
they
do
have
you know?
declared him as highest
How
bidder.
do you know, Mr. Sahu?
Yes,
that
yes.
it
There
will
is,
be
my lord.
given to the respond number 5.
Page 22, my lord. Highest bidder.
Yes.
In the right side, highest bidder, DD to be, in the left side, DD to be deposited by so and so. That was there.
Where?
Below that page 22, not so legible, but in the
Where
bottom
do you
side,
get this?
21 to typist.
Yes, what do you say, Mr. Mr. Gogoi, what do you say here?
Lordship,
What is your stand?
here Lordship, he has participated Lordship. In paragraph 10, my lord, very specific regarding the register cooperative society part Lordship. Page 55 Lordship. Page 55.
Box was open in presence of bidders at the stipulated time, and at the time neither any bidder claimed regarding belonging to the fishery society nor produced any registration. Even the registration number not mentioned in the bid sheet dropped in the event. Hence, highest bidder is considered. What is wrong?
My lord, second ground. Kindly come to
First
page,
is gone.
page 20, my lord. No, that is still there, my lord. And
No,
second,
I'm
second
saying
ground.
it.
At-
Yes, one by one.
no, actually, they have not asked.
So what? You knew when you are relying on a particular document, you should know what is there. Anyway, tell me, second one.
Second one, we wrote at page, kindly come to at page 20. That terms and conditions, clause C. The license is only for 2 years and allotted to the highest bidder, duly giving first right of refusal to the present occupant. The commencing date for further period of 2 years will consider from the signing so and so.
Duly giving first right of refusal to the
To the
present
present
occupant.
Means, my lord, they have conducted the auction, and the auction they found that somebody is giving them 25% above the reserve. Then the offer will given to me that so and so is giving 25%. If you want, then you take, or if you refuse, only then he can get it. That is the meaning, my lord. So I was not offered. And the
Yes, what do you say? You are going to offer him?
No.
Why?
This as per the open auction process, Lordship, yes.
No, how do you take care of C?
C, Lordship. C part, Lordship, there was a title set also, the RSF proceeding also there, Lordship, regarding between them, Lordship.
Huh?
Between that particular decide.
No, but how do you take care of C?
C, Lordship.
At the end of the day, Mr. Sahu.
Otherwise, it is a Lordship, public auction, Lordship.
Understood, but why on earth did you put C?
Lordship, that will.
No, you have said C.
Lordship.
You give him an offer, if he doesn't take that highest amount, then give it to the respond number 5. That's over.
I have no difficulty if he is running or he is running.
He is not running. How do you take care of C? Yes. Explain how do you take care of C? This is the term of the agreement. Of the tender notice.
Yes, on what?
The licensee
Yes.
is only for 2 years and allotted to the highest bidder, duly giving first right of refusal to the present.
How he show, my lord, he is a present occupant, my lord. On which document shows that he is a present occupant, my lord?
Is he the present document or
There is no
not?
document.
No, he has
used,
railway has admitted.
Railway have admitted. Then how do you take care of C?
Nothing is there, my lord. Can you see it?
Well, let us see the railways activity where they have admitted.
They are not put anything, my lord, regarding their present occupant, my lord.
In reply, I have.
Let us see where it is. Petitioner was allotted 2 numbers for fishing at Bullockguns and thereafter on demand the matter is substituted. That in the last order dated demand there is no clear instruction was found for preparing the petitioner for any complaint, thus the same owner was put to press auction dated demand and respectively auction was held on so and so under the supervision of the respondent court. What do you say? And thereafter, from 1/2020, 2003 to so and so, the matter was under subdivision. That in the last order of the case in so and so, there was no clear instruction was found for preparing the petitioner for any consideration and thus the same on date were picked. So you are running it by filing cases.
My lord, earlier against me. Earlier cases were against me because I was awarded and somebody had challenged.
And you are filing RSA.
They have filed, not I am.
They have filed RSA.
RSA
RSA has come and reached the High Court out here means although 10 years must have gone.
Most probably, my lord.
Then what is the RSA? Yes, then that is over.
But
show me your last settlement.
Yeah.
Show me your last settlement that you are the present occupant. Show me that. Show me the last settlement. You are taking that ground, where is the last certificate?
That's page 67, my lord.
Page
Page 67,
67.
67.
Huh? 66.
67 annexer A.
24/12/2002.
Yes, my lord.
Licensing for two numbers of a proposal for licensing for so-and-so as per plan. Submitted by you, duly certified that this is the first proposal and there is no other proposal. Now you are requested to give this possession to the constituent and collect the refund. It has been given for, and for how many years is this?
For 2 years, but due to litigation.
Oh, you are running.
But now, my lord, if
Now tell me how much dismiss with how much cost? We start with every year you are making a profit of 20,000. So from 2004, 20 years,
20 years.
we have not done.
20,000 into 20, 4 lakhs, 4 lakhs 20,000 cost. 4 lakhs 20,000, absolutely no. It is a case for dismissal right away. This is the case by which you heard Mr. S. Sahu, the learned counsel. You cannot run like
My lord, last document, who is?
that would not apply. That clause is not going to apply because of the fact that you have running through some cases out there, and your writ appeal has been dismissed.
No,
You are Bholanath De.
no, my lord. Wickerman Society, my lord.
Huh?
I am Wickerman Society.
Who is Bholanath De?
He filed against me, my lord.
Then? So how do you continue? Tell me, how do you continue for 22 years on the basis of one allotment? Tell me, how is it possible? Therefore, this is a case.
My lord, first one.
No,
Regard-
dismissed with cost of 4,20,000 because it has a significant. The first three numbers have the prefix to this number. First three numbers have significance.
Today's let from process of this.
Huh?
Today's amount was just correct. How much today's cost?
They have not imposed any cost.
That's a lot.
So 4,20,000. This is a case by which the petitioner have resorted to all means for the purpose of retaining the possession and control of a fishery under the respondent railways. Then this is a case where petitioner have resorted to all means available under law so that the petitioner could keep possession of the fishery in question. Heard Mr. S. Sahu, the learned counsel, appearing on behalf of the petitioner. Mr. K. Gogoi appears on behalf of the respondent railway, and Mr.
Isar Ahmed.
H.R. Ahmed, who appears on behalf of respondent number 5. The facts of the instant case would show the materials on a record of the instant case would show that on 24/12/2002, the petitioner herein was licensed was given the license of railway ditches oblique ponds, bracket 2 numbers at Bologna in between TP number 46 oblique 13-18, measuring an area of 151.2 meters into 76.25 meters and 82.35 meters into 76.25 meters as per that is as per plan, totaling to 13.31 biggers for a period of 2 years. On the basis of litigation carried on by the petitioner, for the last 23 years, the petitioner has been in occupation of the said ponds, ditches oblique ponds. Full stop. On 17/1/2025, in view of the dismissal of RSA number
143/2014.
143/2014, the respondents railway have issued a auction notice for the 2 ponds for a period of 2 years. The petitioner herein participated in the said auction process along with various other bidders, including the respondent number 5. Admittedly, the respondent number 5 have quoted, admittedly, the petitioner did not object to the tender auction notice, rather participated in the same. The said auction, the bids were opened at 15 hours on 24/1/2025. And neither the petitioner nor any other bidder claimed or produced any document that they belong to the Fishery Society or have mentioned any registration number in the bids. The bid submitted by respondent number 5 was found to be the highest. And the petitioner, on coming to learn, rushed to this court. By filing the present petition, this court, by an order dated 4/4/2025, issued notice. And in the meantime, the petitioner And in the meantime, direction was that issued to the respondents railway not to finalize the auction notice dated 17/1/2025. The interim order thereafter have been continued from time to time. The respondent railways have filed an affidavit in opposition wherein they have categorically mentioned that the petitioner was allotted two numbers of ponds ditches for the fishery fishing purpose at Golokganj near the shed in the year 2002. And on the account of the matter being sub judice, no steps were taken for re-auctioning the same. However, as there was no order produced, thereby permitting the petitioner to go ahead with the said auction produced, thereby permitting the petitioner to run the said ponds oblique ditches. The auction notice dated 17/1/2025 was issued. In the affidavit in opposition, it was categorically mentioned that the petitioner never raised any objection during the tender process, or rather, the petitioner participated in the said tender process. It was also mentioned that the petitioner never mentioned that it was a fishing cooperative society and provided any registration number of its registration number. Good. The respondent number 5 has also filed an affidavit in opposition, wherein the stand so taken is parameter is similar to the stand taken by the respondent state railways. The petitioner herein have assailed the tender, have assailed the decision, and the petitioner herein having come to learn that the respondent number 1, respondent number 5 is the highest bidder, have filed the instant writ petition. No, this court have duly heard the learned counsels appearing on behalf of the parties and given an anxious consideration to the same. The petitioner have assailed the action, the purported action of the respondent authorities to hand over to the action of the respondent authority in proposing to settle the ponds oblique ditches in question in favor of the respondent number 5, primarily on 2 grounds. The first ground is referring to Rule 704 of the Indian Railway Works Manual, which stipulates that in case of lease of right of fishing by the public auction or tender, the first preference should be given to the fishermen cooperative societies formed by railwaymen. If no such society exists, the second preference should be given to other fishermen cooperative society. And if there is no such society exists, it may be let out to others by public auction or open tender. The petitioner herein admittedly did not apply as a fisherman cooperative society. Under such circumstances, the reliance to Rule 712 have no relevance. The second ground on which the petitioner have sought for interference from this court is on the basis of clause C of the notice inviting tender of the tender notice dated 17/1/2025. The said clause C being relevant is reproduced hereunder. The petitioner herein contends that as the petitioner is the present occupant, he should be given the first preference, given the right of refusal. Admittedly, the petitioner was only granted a settlement in the year 2002 for a period of 2 years. In the opinion of this court, he cannot be considered to be an occupant of the fishery in question or having any right in respect to the fishery in question, inasmuch as there is no orders produced before this court that the petitioner have been granted any extension after 2002. Under such circumstances, the said ground on which the petitioner have assailed the actions on the part of the respondent authorities also failed. Accordingly, the instant writ petition stands dismissed. It costs quantified at rupees
My lord, at page 24, we have applied as a Wickerman Fisher Cooperative Society. Seal is there.
enclose the number.
No, not. But-
Number is
but-
not
Name?
by name. Their name.
The society is there with us.
Where is your certificate?
Yes, at page below,
No
At-
certificate.
at page
It was not submitted at the time.
14. With
It
the,
is
with the
submitted.
tender not submitted, yes, my lord.
Huh?
With the tender not submitted. We have submitted in this writ petition.
Let me also be a tendering authority one day.
Oh, like,
What is that? For that matter, it didn't reach. It's confirmed.
Admission.
কোনটি?
Item.
একটু হয়ে গেল। 9 হয়ে গেল।
9, 10.
It's a date. When do you want all these matters? Anybody? 9?
No state.
9, anybody has any?
Yes, Silat. 9 and 10. my
You
lord,
want-
can you
When
pick-
do you want it?
My lord, is if
We're
it
enjoying
goes-
an interim order.
interim order is there, my lord.
We do it after vacation.
Yes, my lord. My lord, can you fix it that, my lord?
Huh?
Fix it that, my lord.
What?
My lord, can you fix it that, my lord? When after vacation?
Okay. At the request of the learned counsels appearing on behalf of the parties, the matter stands adjourned to be listed on 28. What is the matter about?
My lord, regarding assessment. Assessment, my lord.
126.
Yes, your lord.
On 27th of October 2025, interim order passed earlier shall continue. Your objection is 127, nah?
Yes, ma'am. Sorry?
Your case is under 127.
127, ma'am.
27. Yes, Mr. Das? When do you want it? Huh?
After vacation. A small issue, Lordship can held up, not take much time. Very small issue.
Earlier to 2 p.m. Tomorrow at 2 p.m. Small issue. Is the matter tomorrow at 2 p.m. Then, number 12.
On Thursday, but otherwise, my lord, the sanction has.
Oh, this case.
Yes,
Yes,
sanction has been given.
this I'll take it. Wait. Yes, what has happened?
But the sanction has been given by the approval has been given by the financial.
Even. So now he will be getting his pay. Huh? Okay, now what do you want?
It is on the registry, man.
We have the finance has given sanction from 1/4/2025 to 31/3/2025.
So thereafter, if you don't continue him.
If they require, they will continue.
No.
Otherwise.
No, but he cannot have a right. First of all,
Yes.
you see, every person's appointment which is there, you are giving these fixed casual employees peon. And every year if you do it on basis to this, then it becomes a difficult. And you should not be doing it in this manner. That, okay, until further orders, it cannot be there.
It can.
His appointment has to be restricted to 31/3/2026. We do one thing, we take it up tomorrow, I don't want to fix it at 2, na? Day after. Day after I take it up. In the meantime, I'll pass an order to the effect that his appointment has to be restricted to this. So therefore, you have to restrict his appointment to 31/3. And thereafter you enhance, but subject to approval.
Yes.
You know, this time I have done it, but next time you cannot. You get the point?
Yes.
You'll get your money this time.
Sure.
And your job is also saved because of me. But the fact remains the next time it cannot happen like this. And it is absolutely your mistake. Mr. Busho, you have to be more careful. I mean, not you. Your people have to be more careful on this. When they have taken it, okay, until further orders. Do they have the money? They think that they are the government. And the court should know that we are not the government. We are, and on one hand, we say independence of the judiciary, and sometimes the court tries to function as the state. Okay. Mr. B. Gogoi, the learned additional advocate general, has placed before this court that there is the finance department of the government of Assam has granted an ex post facto approval for the engagement of the casual employee peon under the establishment of the member MACT Gwalpara for the period from 1/4/2025 to 31/3/2026. The said communication, the said orders, the said instructions are collectively kept on record and marked with, I mean, record or document we have. I think, Mr. Gogoi, I think I should pass an order in this case only, making this thing clear.
Well,
Because for all
yes.
times this has to be
Yes.
on record and collectively kept on record and marked with the letter X. It's this matter again on Thursday.
11th.
Thursday at 2 p.m. Huh?
Lordship.
Thursday, what is it going on? And we should be thankful for Mr. P. Gogoi for getting it done. It's otherwise a very difficult thing. But the court should also understand that it is not to embarrass themselves on one hand to become administrative authority.